Transfer matter. One transfer matter.
Transfer matter. When transfer order is issued?
Transfer order issued last 20 days before.
Not yet reported there.
They have filed a representation thereafter in action of the representation.
They are
I'm challenging the gradation list, my lord. The 20% reserved for promotion from Group C to Group D. Now, the government directed to fill up all the posts now.
Next.
I have filed IA, my lord.
Old matter, 2023 matter or correlation matter?
Matter relating to
pension matter. Pension not given. Pension not given.
After he got the pension for 3 years, sir, continuous 3 years, sir, they have cancelled.
My lord, this is
Next week we can have.
my lord, this is after notice matter, lordship. This is after notice matter.
Reference to daughter.
My lord.
Next week.
This is after notice matter. Plot has already been allotted.
Which year?
2024. Plot has already been allotted since but they are not handing over the possession.
Possession is not.
Lordship.
2 weeks.
My lord.
I want to mention the matter relating to pension.
Next week.
My lord, petitioner is not getting single pay, my lord, after retirement.
Next week.
This week, my lord.
This week we have difficult. Otherwise, I have doubting that.
Well, this
The matters are same.
this case,
Appointment to the post of PG chairman is under challenge, your lordship, of the FM University.
In which year it was?
It is 2024 year.
24. Week out.
My lord, pension matter of 2024.
Pension matter. Next week.
well, this is a contempt matter, my lord.
Contempt matter.
Less contempt, my lord.
Next week.
My lord, it is not contempt 2015 order, my lord.
Next week.
Another is, my lord. This is a appointment under rehabilitation assistance scheme. Also contempt.
2. It's also contempt.
Years also contempt. This week, my lord.
Academic matter, my lord.
Academic. What is that?
Petitioner prayed for correcting his name, my lord.
Correct name.
My lord.
Day after tomorrow. We have similar matters, sir. Just look into. We have passed similar orders where the learned government advocate had appeared, PG had appeared. Just look into that.
But 24 matter, the applications are pending similar issues. Kind one matter not decide to the
Matters are disposed of.
No. Similar matter is pending in 10-20 matters.
How many matters are there?
They really bonus is a
Do you have connected matters?
Yes, sir, connected.
You have written them.
One matter I have given, one matter.
Okay.
So, when matter is along with 3 copies.
I don't to mention, item number 12 is not assigned to this bench. Item number 12.
Item number 12.
Wrongly listed.
Listed here.
Vote number 1. Vote number 1 may be listed.
Learned counsel for the your petitioner.
I am for the petition.
Learned counsel for the petitioner submits that. And the matter requires reclassification for being posted before the roster bench. I must agree.
Item 6. Very matter. Tomorrow.
Yes, register to very
But tomorrow the matter.
and post the matter tomorrow.
Item 16 also, my lord.
To the assembly.
Needed urgency.
Item 16 also same, my lord. This matter also
1/6.
1/6. This also not assigned to this bench, my lord.
Yeah.
Page 317 is the 30. Page 4.
Two persons are there, na?
Item number 1.
Make use of the mic. Be loud. Yes.
May I please your lordship? May I please your lordship? Item number 1. My lordship, it is an
Old item 51, lordship.
51. Of which year?
Item 51, I am for the petitioner.
Which year?
21, lordship.
21. No time.
I have received the counter.
You might have received it. You can keep it in your pocket. 2021.
No, I have just before one day before received the counter. So kindly file the
Call after 2 weeks at the request of learned counsel for the respondent who seeks to file
I have taken the consent from the other side.
counter. First, whether counter in contemplation after filing to be taken on record is kept open. Yes.
Instrument is there, lordship.
We have passed the order. If you are aggrieved, you have remedy. You are for the petitioner.
I am for the petitioner. I am for the petitioner. I have taken the received the counter. I have received the counter, filed the rejoinder.
When objections were filed, counter was filed.
Counter received
When?
Before.
Don't lie, because I will verify that right now.
Previous.
You are not answering the question. The question of the court is remaining unanswered. So it's not a habit. There should be answer this side, that side. Or confession saying that I cannot answer. Patient.
1 month before also.
2 weeks. I do not know what you are going to do.
In theory, also.
We do not know. We are giving you time. We do not know what you are going to do. Yes.
Item 1.
My lordship, may I please your lordship? Item number 1 is your old certificate correction matter. My lordship.
Why our rights are not voice of the lawyers are weak? Cases are also.
Certificate correction matter. My lordship, the petition.
Here I have received copy of the writ petition. The entire prayer of the petitioner is to dispose of the representation given by him for correction of his name.
Correction of?
Name.
Name in subsection.
Date of birth.
Date of birth.
Date of birth.
Date of birth. So I would like to put in my appearance and let it come next week. I'll find out whether that representation was already disposed of.
Is there any limitation for seeking the correction of date of birth?
3 years.
3 years.
My lordship, it is
There are only 2 conditions. One is it should be a clerical mistake. Number 2 is it should be filed within 3 years and should be routed through the head of the institution who has given the certificate. So whether all these things are complied with or not, I will have to check out.
Learned panel counsel Shri appears for answering this upon OPs, all OPs.
I am only for OP number.
AGA for 1.
No.
AGA for 1. Panel
I am for 43.
3. 1 and 2.
1, 2,
1, I appear for 1, 2,
4.
4.
1, 2, 4. Panel counsel for OP number 2. First, since a short issue is involved, call this matter next week.
specific date, my lordship.
Come next week. One day this that side because of urgency. Come to. Yes, sir.
Sir, actually, this matter is
Just one judgment of Karnataka High Court. Brother, 1 second.
I will inform.
Where is he? Sir, he has gone. There is one famous judgment of Karnataka High Court export and of Vishwanath Rao versus State of Karnataka. Just look it. Yes.
so this matter is read 12-12737 of 2025. Actually, this petition,
You are for
I am Saurabh Sekhar Behra versus State of Odisha.
14%.
Yes. Yes, my lord. I'm 13% for 12737.
What is your prayer? Read the prayer.
Actually, let me start, sir. Sir, my lord, actually, this petition 12737 is carrying original matter of petition 20808 of 2022, which has been already instructed by Supreme Court on order dated 29 of 2022. If you want to notice the order, then you have to go through IA of 2. Interlocutory application number 12565 2025. Kindly move on to page number.
What is his prayer?
My lords, 20 page 27. Your lordship kindly read page 28.
28.
Para 5. There is some problems. Your lordship should read this para. Para 5 onwards.
Schizophrenia.
He has some problems. That is why he repeated petitions without any substance is filing.
No, this is carrying substance actually.
Please, what I am answering.
Okay, no problem.
Yeah.
Sorry.
See, this is earlier round of litigation.
And his writ petition doesn't make any specific prayer or any ground.
My lord, let me start from my side. If sir is
Yes.
actually,
I asked him, therefore he is assisting.
okay. Sir, actually, these are two separate matters. One is SCB and one is public servant cheating. So here I am repeating the public servant cheating. Actually, what happened in matter number 1095 of 2023, they have just taken the notice of this order. Decided something in that matter 2080. Just I'm producing it. That's it. So
Which public official has defrauded you?
State of Odisha. State of Odisha, government of Odisha actually matter. It actually court decided 50%. Then court ordered some grievance to the state authority, and grievance has been redressed.
Issue notice. Post it in regular course in the order of seniority. Okay. Steps repeat within 6 weeks. Okay.
Lordship wanted
Item 1.
Item 1. There is one judgment of Karnataka High Court relating to change of date of birth, service record, school record. Vishwanath Rao versus State of Karnataka. It is in the light of determination of age act. There is one statute like that. I do not know whether you have such statute. Just look into it, because it will have many consequences on other people.
Here also the service code, Orissa service code
Mentions that.
mentions a particular period when the correction is to be made in the service.
Okay. Next.
Item 3. May please minutes. Here one advertisement was flouted by the state with regard to different posts in the government high school, Malos. That is annexed to the various districts of Odisha. The petitioner filed the application for the post of physical education teacher in the district of Ganjam, which had notified 85 number of post Malos.
Total 349.
Total 349 for the PET Malos, physical education teacher, it was 85.
85.
Lordship may kindly glance Malos.
Then what?
Thereafter, a merit list was done. My name was not there, Malos. Thereafter, another applicant, namely Randhir Kumar Biswai Malos, he filed an application before the learned tribunal challenging that merit list on the ground that it has violated the reservation policy and it has exceeded more than 50% Malos. The Lordship may kindly glance at the tribunal order. Annexure 4.
No, here they have exceeded 50%.
Previous Malos, they exceeded.
So if that excess was not done, you would have been selected.
Malos, I will come to that. I'll come to that. They have corrected that. I was named in that merit list after this tribunal's order. Learned tribunal value, annexure 4, the relevant page being 36. I read that out, Malos. Page 36. The second part, during the submission of the learned counsel for the applicant.
In the writ of Indra Sahni, it was
Indra Sahni Malos, it was there. The learned tribunal says that
out notice. Learned AG.
Well, it's in fact the select list he has challenged. There are a lot of persons. They should be included. Otherwise, any order here may affect them also.
But it may happen. It's only select list. Right to merely because one is selected, he has no right of appointment at all.
He should be given.
I will clarify the position what my learned meant.
Suppose if you are allowed, your petition is allowed, who will be disturbed?
No one will be disturbed.
No one
will be disturbed.
Because number of vacancies.
More people will be added rather. I have included 2 persons as party Malos to answer the query of learned state. This has again violated the reservation policy and the learned tribunal's order.
Understood. Even otherwise, they will not be affected.
No one will be affected. Rather, more people will be added, including the present petitioner.
All right. Learned AGA issued emergent notice. Learned AGA requested to accept notice for respondents 1 to 4.
1 to 4.
Emergent notice 5 and 6.
They are the selected persons. I pray that let no notice not be issued to them.
Once you make them party,
Yes, I will have that.
is it not? Otherwise, res judicata will apply.
Yes.
For them, it may be difficult.
Yes. I will send them. Within 3 working days.
Yes, 3 works. 4 days.
Great.
Item 4.
But pursuant to your lordship's earlier order, my representation for grant of seniority from the date of my initial appointment has been rejected by 12 at page 56.
It is rejected.
Rejected.
On what ground?
On the grounds that
You wanted regularization from the date of entry into service.
entry into service.
Have they given it to any other person? Then non
information.
they are asking for regulation because Supreme Court said in literate.
No, it is not that. It is a case of rehabilitation appointment not being made in the original district and
in other district
in class 4 job.
What is your right that you should be appointed in the very same district?
That is the rule.
Show that.
Under same appointing authority.
Show that.
That rule I have not brought today, tomorrow.
Next.
It is district cadre post, so it is good. All right.
When you ask time, you are not supposed to argue even one word.
Tomorrow.
Next week.
Item 5.
But it is matter.
My lords, there is no cause of action. Your lordship will find one copy of judgment.
How can you dismiss in his absence? Client may mistake.
Next week.
Next week. Available counsel for the petitioner to come and argue. Yes.
Item 6.
You may dismiss it after hearing.
My lord.
May I say second round litigation?
What is
Annex 8 is challenged.
Annexure
8.
8.
Yes, please.
Go to annexure. What is that?
Rejection. Rejection order.
What
Similar.
was your representation?
Similar order passed by him.
It's already agreed.
Yes, please.
All right. Issue emergent notice. Learned AG is requested to accept notice for all respondents. We call this matter along with in the first week of September.
Item 7.
May it please your lordship, my lord. I am VCR Puri, my lord. My rescue submission before your lordship, please make a class to the annexure 1, my lord. Running page 15. This is being the certificate issued by the authority concerned in favor of the Baba Deveswar Auto Jalago Sangha. The petitioners are the president as well as secretary of that Sangha, my lord. They have also, please make a class the annexure 1, running page, my lord. Please make a class.
What is that?
The matter regarding the petitioners are the auto chalaka members of the auto chalaka sangha. They have been allotted for parking and to strengthen their business. The area allotted to them, that is, please make a noise, running page 16. Area and occupation of jurisdiction. And at present, the association will be operated within the area between the Raj Hotel to Hotel Starling, Baliakonda. This is being the bylaw. As per said bylaw, they have been also using their business through auto in that area. But the private office, they have also forcibly, they try to remove them from their occupying area. As a result of which, by annexure 2, running page 38, a repentance is pending before the collector. I duly submit before your lordship, at least repentance may be disposed of. By annexure 2, running page 38.
Their autos
My lord.
is considered as an individual, right?
My lord.
Though collectively they are members of the association.
Your lordship may issue notice, another private parties are there.
Yes, issue notice, emergent notice. Learned the AGA requested to accept notice for the office.
1, 2 only, my lords. 1, 2, 4.
1, 2, 4.
My lords.
One is the private party, 2 is private party.
No, my lords. One is, I will appear for 1, 2, and 4.
And 4.
My lord.
1, 2, 4. emergent notice to the rest. 1 week.
Kindly fix a date, my lord. Please, kindly fix a date, my lord.
Not a good culture that judge fixes the date on the first day. What impression it will give to the members of the bar?
Sorry, I'm excused. Sorry, I'm excused.
You cannot post immediately after the release. Yeah.
May I please, madam? Kindly have a glance at order.
Well, there is order for instruction, taking instruction.
On 26th June.
He's saying, yeah.
My lords, I seek little time to take instruction.
When are you filing?
My lords.
Next week you have to.
My lords.
At least 2 weeks you have to. Within
2 weeks, and my lords, the answering is opposite party number 4.
No.
Let notice go to 4 and 5.
No,
my lords.
Complete the sentence.
My lords.
Why are you? It was Oscar Wilde who said, I can resist everything except temptation. Perhaps you are doing that.
My lords, 4, OP4 is the Secretary Board of Secondary Education.
Is a different party.
5.
Notice is not served on.
No, it was not. And 5 is governing body. My lords, what?
Notice to them also.
I am explaining. Not necessary. They are.
Why did you make them part?
Yes, the only pro forma for the sake of any, but I don't have any.
Then delete them.
Yes, I am prepared to delete. But yes, I am prepared to delete them.
You file memo. Learned.
Yes.
Learned counsel for the petitioner seeks leave to delete respondent number OP numbers 3 and 4 from 2
and 3 are necessary parties.
No,
1, 2, 3. 1, 2, 3 are necessary parties.
Only 4 you are.
Yes.
4 and 5.
4 and 5, yes.
4 and 5.
I don't have any grievance against
You
them.
may give them. Learned government advocate does not have objection to the same. First, the above circumstances, request is allowed and leave is accorded. Petitioner to amend the cost title right now. Give the paper. Yes. Next week you will be able to file the objections.
My lords, 2 weeks. 2 weeks.
All of 2 weeks to enable filing of, to facilitate filing of counter by the answering respondents, failing which, right to file one forfeited. After 2 weeks, it is forfeited. No right.
My lord.
Interim order may continue.
What interim order?
Interim order is yes, no. I am allowed to continue as a lecturer in English in the college.
Since how long you have been working?
I have been working since 15/7/91.
15/7/91. First, learned counsel for the petitioner, turning the pages of the record, submits that his client has been working since 1991.
15/91. 15/7/91.
15/7/1991. And now he apprehends that he may be disengaged and therefore he should be protected from such possible disengagement. First, I agree. First, in the above circumstances, an interim direction is issued to
on 26, but
issued to whom? Interim order. Direction to whom?
To the authorities, to the Property Department 1, 2, 3.
To the respondents, not to disengage the services of the petitioner without leave of the till next date of hearing.
Item 9.
May I please, Your Lordships?
Yes.
My lords, here in this case, the petitioners were allotted certain plots under a particular scheme formulated by the Baleswar municipality, Your Lordship, at Annexure 1 series.
Take notice.
Lordship. Second round litigation, my lord.
Yeah. Second round litigation.
Yes, Your Lordship.
Yes. Who appears for whom? Just you have to tell me.
My lord, 1 and 2 state can take notice. I have to take notice for 3, OP3.
JGA forwarding to emergent notice to be number 3.
Yes, Your Lordship. Great.
Second round of litigation, na?
Yes, Your Lordship.
Yeah.
I may please your lordship.
Yes, sir.
My item is chronologically item 10, Your Honor, in
10.
serial.
Correct.
But all the cases they have revoked their license issued by the competent authority. But my petitioner have not been revoked. Lordship, I will have a glance to the Annexure 2, page 11. That is the subject matter of challenge.
WPC number ta kahi.
What is your grievance before?
Grievance before, my lord, I am pressing. My writ application is
17429.
no, my lord. 19,436, my lord. Last item.
19,400. What is the subject matter of
Subject
this?
matter. I am pressing, my lord.
I do not read papers because I may form opinion and come to court.
Yes, my lord. I am placing the things in a rightful manner, my
I am
lord.
telling you something.
Yes, ma'am.
Which you have to advert to.
Yes.
I am telling to everybody. I do not much read the papers because I will form opinion after reading and I sleep with the opinion.
Yes, ma'am.
It comes very dearly to me.
Yes, ma'am.
And I may not agree to dislodge the opinion at all.
My lord.
Or with fresh mind I come. So that if there is a prima facie case, I'll admit, then I go for hearing of the matter.
Yes, my lord.
What
I am
is the
placing
subject
it.
matter of all these petitions?
The petitioner, first of all, were appointed to register by the law department. Lawfully, they have been appointed to discharge the duty of Mohammedan marriage and divorce registration. And the petitioner, in this case, have been appointed duly by law department way back in 2021. I have annexed that in my now, by way of a circular,
They have revoked the licenses.
Huh,
It is the case of license.
license.
Under which law?
Which law? I am placing my law.
Register and
Which is that?
I am placing
Register certain.
act.
Marriage law?
My lord, Mohammedan marriage and registration.
Yes, read that.
Yes, my lord, I am reading. Your lordship, I am placing the reliance upon the Orissa Mohammedan Marriage and Divorce Registration Rules 1976.
That rule
That is rule is framed thereunder.
framed under which act?
Which act is 1949 Act. Act is principal act by the central government, my lord. In view of that,
Central government or parliament?
Government of Odisha formulated rules in 1976.
That is section 24 of the state government. Orissa Mohammedan marriage.
Central act. Rules
ଏଠି ଲେଖା ହେଇଛି କଣ?
Not parliamentary legislation. It may be novel, but
State Act. Orissa Mohammedan Marriages and Divorce Registration Act 1949.
yes.
39.
49.
Yes.
489.
As to the section 3.
That's what I am reading.
As to the section 3.
That's what I am reading.
Yes, my lord.
Rule 3.
Rule 3, my lord.
To my lord, my lord.
Yes, I have got that.
Yes, my lord. In pursuant to that direction, duly appointed, the petitioner duly appointed.
Please, duly appointed, I have go further. Say something new.
Yes. There, by way of a circular, that cannot be override the statute, my lord. That is my whole point.
For what period you were appointed?
Unless and until that is revoked, that is continued.
Where is that? One.
Yes, my lord. Showing it.
Show that.
Your lordship, kindly have a glance to the page 9, annexure 1.
Page 9, annexure 1. In your WP.
19,000.
In your WP.
19436, I am placing.
19436. I should see which paragraph, which annexure 1.
Yeah, yes, my lord. Annexure 1, page 9, my lord. I may permit to.
One second, I am reading.
Yes, my lord.
Suspended by the state government. It is not permanent certificate, and certificate. I have not completed the sentence.
My lord,
I have not completed the sentence.
Yes, my
We
lord.
should allow the judge to complete the sentence.
Yes, my lord.
Firstly, the license is not for eternity. It is not a permanent Achandrark license. It is until further orders.
My lord, kindly have a glance to page 10 also.
Then also. It is sent to you.
My lord. Right from that day, without any interruption, appointed the Maulavi who are well adversant with the Mohammedan marriage and they are appointed. Consequent upon that, petitioner continuously doing it, apart from doing the official work which is entrusted to him, school duty. It is not a
What is that official
servant.
work? What is that official?
I am working as a employee. Government employee. That is not bar. Your Lordship have a glance. I have annexed the who can appointed. Your Lordship kindly have a glance. I have marked in flag mark I have given.
Even government employees also can be appointed.
Can be appointed.
Where is that?
My lord, your Lordship kindly have a glance to that.
Rule?
I have marked in I memorized in that flag mark I have given you in yellow color. Lordship have a glance to the format itself.
Rule.
My lord, what I have supplied to your Lordship, on that I have marked it.
Rule
1976 rules. ये बड़ा फॉर्म था, फॉर्म टच 76 rules का फॉर्म टच बी फॉर्म ना फॉर्म बी फॉर्म.
Government pensioners can be appointed.
Yes. Pensioners as well as though Maulavi, those people are teachers, they are Maulavi also.
Yeah,
They are also
No, not
Maulavi.
like that. Not like that. They cannot do that. Because if they wanted to say that, they would have said government pensioners, including the government servants who are Maulvis. They would have said that. They cannot that way.
My lord, my respectful submission would be the person who at the time of relevant time of application, he was also in posting. And the government has only because they have well advanced knowledge relating to the Mohammedan law and marriage. That is why they have been duly appointed as
No, they say government pensioners. Means, but those who are in service cannot be appointed. Otherwise, where is the meaning for this word?
My lord, in the next paragraph, the service particulars may be given in that paragraph that was
Service
written.
particulars relating to pensioners.
No, my lord. In that service, whether in service, that can be also furnished by that form.
Where is that?
My lord, that copy, one copy there. That is why I am not ready.
There is one maxim which Maxwell on interpretation of statutes discusses.
My lord.
1 second. You should understand the law. You should resist your temptation to celebrate ignorance.
No, my lord.
Don't celebrate ignorance. Listen to me first.
Yes.
There is a
yes, my lord.
in Maxwell's interpretation of statutes. Call it from the library. Expressio unius exclusio ulterius. That maxim says where something is expressly said, unexpressed things are ruled out. Perhaps you have never seen that book at all.
My lord, I have, your lordship kindly have a glance to the 4 column.
Yes.
Form number A.
Forms will not govern the rule. Forms will not govern the rule. If there is divergence between the rule and the form, the rule should prevail. That's what Apex Court has said. That will not help you. Any other case which you are mentioned, we don't agree because you have not seen that book. Have you seen that book? Have you ever seen that book? Maxwell's interpretation of statute.
Maxwell interpretation of statute I have seen.
Yes. Can you?
My lord, a statute cannot be overruled by a rules.
1 second. Rule is there. Statute does not provide for appointment. It only gives the guidelines. Rule provides for that. There is a maxim in Maxwell's interpretation statute, which I was taught in the law school. Expressio unius ulterio exclusio ulterius.
My lord, may I respectfully submit
Yes,
my
said that.
As your lordship has said, if it is something expressly mentioned, then other things will be excluded.
Excluded.
I doubt-
Ask the librarian to bring
Your lordship may,
ask the librarian to bring that book.
your lordship may kindly consider, here it is the rule says, it is not excluding others. Here it is saying, shall be given. It is not that only they must be given. I am reading the rule, my lord. Who may be nominated? Rule 3. A person to be licensed as Mohammedan register should have sufficient acquaintance with the Arabic language and Mohammedan law of marriage and divorce and be of good moral character. Preference shall be given. Preference shall be given to ex-Qazis and government pensioners, being Mohammedans, Maulavis, Khundakars and Mullahs who reside or are willing to reside at a convenient place within the limit of proposed jurisdiction, provided they possess the adequate qualification. This is the preference.
We don't agree. A government servant cannot go on doing private work.
My lord, may I submit?
That affects quality of his performance in the government office.
May I submit, my lord?
Yes.
It is your lordship, the registrar of Mohammedan marriage and divorces.
Yes.
The question is not Qazi. Now, in Muslim marriages, the presence of Qazi is sine qua non, your lordship. That is, the Qazi must remain present. It is not the thing. The Act says Muslim marriages may be registered within 1 month of the marriage.
Which Mohammedan law book says presence of Qazi is a must for Muslim marriage?
No, that even your lordship in absence of
said
no,
you use the word sine qua non.
Yes, your lordship.
Therefore, show that.
My lord, my submission before your lordship.
Have you brought the book?
No, Mohammedan book I have not got. Rules I have got.
No, you are saying.
Yes, my lord.
Qazi is a must for a Mohammedan marriage.
My lord.
I do not know.
My lord.
Just show that.
That your lordship, exactly Mohammedan law and Mohammedan books I have not brought because rules I have in it. My lord. With respect, my lord, I am submitting.
No. Unless you prepare fully.
Again.
You can't just throw some snake and go away. You have to bring your books. You have to first, sir, I have brought the books. Then you can do, not half-heartedly. We cannot treat you as a DF Mullah.
My lord.
You are a member of the bar, I agree. But you have to bring the book because I am ignorant. You have to educate the judge, get the order. All right? Tomorrow?
Next week. In a convenient day.
You have to bring the entire material. You have to tell us whether the government employees can hold other offices. There is such a rule in every state. I assume that there is such a rule in your state.
That is government servant contract rule.
I look into that Maxwell's interpretation of statute also. You can't just make some half-hearted argument and go away. I will not so easily leave you unless you come with full preparation.
Full-fledged.
I come in there. At least I have not read the presence of Qazi is there.
No, that is
Yes, my lord.
In a Mohammedan marriage.
May I just only submit one
No, don't
clarification, my
submit.
lord.
Bring law.
My lord.
Unless you are Palchiwala.
My
I
lord.
can't hear you.
My lord.
Yes.
Only, my lord, one clarification.
Yes.
My submission is that Qazi may not remain present even. But that I submitted because of the
But
government
you
counter.
say-
Yes, your lord, saying. Because of the government counter.
You say.
My lord.
I lie. You said
My lord.
that the presence of a Qazi is sine qua non for Muslim. This is the sentence.
And I said, yes, your lord.
I doubt that.
That is my lord.
I will not say anything more now. I doubt that. bring Paisi or Mullah. Let us see.
Item 11, limited grievance, only direction of Program 5, consider the reference on the annexure 3.
Annexure 6.
Yeah, annexure 3.
3. What is that?
That is a reference on they are giving that the suit is pending in the court. So the reference that the one suit is pending in the senior civil degree. And so that you cannot proceed for any execution or salary or anything. That is, they are given reference on because there is no interim order in the suits.
What is his prayer?
He has paid issuance. He has filed a representation. His suit is pending. And he wants that there should not be any interim order in the suit by way of this representation. How a read court can
only consider this representation.
how a read court can
Is pending. Your prayer is what? Let us see what is your
representation
only to consider the representation.
Consider for pulling down the High Court building.
No,
We cannot give you. Whatever order you want to seek at the hands of the civil court.
Yes.
It's your suit. Your suit. We will make observation so that you can move appropriate application before the suit court and get the order. With that under the shadow of my observation.
Marital disposal
suit for partition.
Suit for there you can seek anything. It's a title suit. OS number? What you call it as? OS number? What in
CS number.
CS number.
2 by 2016.
2013.
130.
132 2016.
2016.
Before the
Second one.
Co-court civil judge.
Senior civil judge Nilgiri.
In the court of civil judge, senior division, Nilgiri.
Afterwards, just write down and give that. Petitioner is grieving before the writ court against non-consideration of his representation at Annexure 3, wherein, in respect of certain property, seeking restraint order, mainly pleading that petitioners happen to be senior citizens. First up. Next paragraph. Learned counsel for the petitioner, please be seated. Sit down. Learned counsel for the petitioner argues that it is the state policy as awarded by the Parliament in 2007 Act, Senior Citizens Act. Full name you have to write. That court should come to the aid of seniors in circumstances of the kind, and the authorities having not discharged their duty in terms of the representation at an exam. Please take that and find out that maxim. Any youngster, give that Maxwell's. Just see that. Expressio unius, exclusio ulterius. Any national law school students in the college courtroom? Any? Take that book. It is after 150, 60 pages. Thereafter it comes separate. There is one best book, Broom's Legal Maxims. About 4,000 odd maxims he has given. Excellent book. All maxims are capsules of law. They come to help. Just glance whenever you get time. Yeah, take that and first up. Next paragraph. Learned AGA on recruiting for the respondents, opposite parties, opposes the petition, contending that in respect of the subject property, petitioners are before the petitioner is before the court in CS number 132 of 2016, wherein a decree for partition of property is sought for, and therefore representation of the kind cannot be considered during the pendency of the said person. First, they recourse in this submission. Next paragraph. In the above circumstances, petition is disposed of, permitting the petitioner to make appropriate application before the jurisdictional court wherein the suit is pending. And if such application is made, the learned judge of the court shall process the same at the earliest and in accordance with law. First, in that connection, all contention kept open. No cause. Registry to send a copy of this order by speed post to private. How many private any private respondents are?
No.
No private respondents? No. Got the point? So much time to find out. It should be done within 2 minutes. Yes. Next.
Item 13.
What is this matter of?
He has prayed for to ban the in social media.
Ban the social media?
Yes, sir. Media.
Why it should
using defamatory words in the social media? He has prayed to restrain the social media against any defamatory words.
You would take for the petitioner?
No, I don't. Yeah.
Here's for the petitioner. Call out. Memo is moved for posting or in regular course, as the case may be.
Item 14.
Item 14, may I please, Your Lordships? Your Lordships, in this matter, my prayer is very limited that I just want the opposite party number 2 to consider my complaint petition.
Consider your
complaint petition, Your Lordship.
What is that complaint?
Your Lordship, the complaint petition is in respect of my wife who has been appointed in a government service, whereas there is a declaration which needs to be given before a government authority stating the marital status. So, Your Lordship, there it has been stated that she is unmarried.
You want you to be shown as husband. Your Lordship. It's a very curious case. There is such a column in that government form.
Your Lordship, that declaration form which is...
Consider representation. Short grievance of the petitioner is as to non-consideration of his representation, wherein he seeks introduction of his name in the service records of his spouse, husband.
Marital status.
About the marital status. First, learned counsel for the petitioner argues that in the service law and the precedents, there is a form which requires every public servant to describe the marital status, mentioning the name of husband or wife, as the case may be, and that having not been done, the government should look into the representation at an exact
2 series, Your Lordship.
An exact 2 series. First up, next paragraph. Learned appearing for the official respondents, having resisted the petition, saying that it involves a disputed fact matrix and therefore petitioner be relegated to civil court, now agrees with the suggestion of this court to instruct his clients to look into the grievance of the petitioner as has been aired in the subject representation in accordance with law and within a reasonable time. First, this is really appreciable. Next paragraph, in the above circumstances, which is board of. First one, time for compliance is 6 weeks. First one, all contentions are kept open. Next paragraph. It is open to solicit any information or documents from the side of the petitioner as are required for due consideration of subject representations. However, in that guise, delay shall not be brooked. First, no force.
Regular. 15.
Could you Yes. Could you get it? Just read.
Well, it's not from Joel's interpretation of statute.
That girl has brought it. You could not locate it. Could you not locate that maxim in the book?
Yes, not in that.
Give that book to me. I will look it.
I have got one. I have.
Give that.
Expressio
unius exclusio ulterius. 1953 Supreme Court said it has followed that. It's a very
2011. It is
which
Supreme Court.
translates to the express mention of one thing implies the exclusion of another.
Correct.
I think 93.
53 Supreme Court is the famous judgment.
Yes.
Justice B.K. Mukherjee's judgment. Expressio unius exclusio ulterius 293. Take this. Just read a small paragraph because many liars will be benefited. Yes. 293. My professor, Professor Seshadri, who was later murdered by misidentification, the great teacher, he taught us in such a way that we will never forget certain things. Just read that one small paragraph.
By the rule usually known
Read the
in
heading.
form of expressio unius exclusio ulterius.
Correct.
By the rule usually known in the form of this Latin maxim, mention of one or more things of a particular class may be regarded as silently excluding all other members of the class.
Yes. It's a very good doctrine. But English courts have treated it as a weak maxim. There are many are not there. Yes.
May I please, Your Lordship?
Well,
my Lord, here the writ application is for seeking direction to the Director General of Fire Service, which is OP number 2, to dispose of the representation dated 10/4/2020.
what you have sought for in the representation?
For regarding opening of a new fire station at Bendka.
New fire station.
Fire station.
Why fire incidents are many there?
The distance of the fire station is quite long.
That's how
For that
any
particular
statistical data? That so many fire incidents have happened. Any statistical data is
It's a highly populated density area that place.
You consider that representation?
Earlier, Your Lordship, earlier government has decided to set up a fire station there only.
There only.
Now, in the meantime, the concerned MLA of the Cuttack Sadar wrote a letter to the fire service, OP number 2.
In some other place.
To some other place. And the OP number 2 and 3 has given their expression that direction of the MLA, the area is not suitable for setting of a fire station there.
But MLAs also will have voice to say in such matters. They are representatives of the people.
But that area doesn't fulfill the government criteria. As for the fire service,
any normative basis is there? Where to establish fire station, where not to? Any rules, guidelines?
No, I don't.
Then how it's all discretionary matter? How we can interfere? We cannot interfere. These are all policy matters. Where to establish, where not to establish. It doesn't depend upon just the population. It depends upon, suppose, if they are growing paddy and paddy grass is stacked there, or some petrol bunks are there, or the crackers factories are there. There are some judgments of the apex court.
Highly inflammable.
At least inflammable circumstances, or many mischievous persons are there. That also can be a ground. But Orissa is a very good state where such people are very, very frugal in number.
They may consider.
No, the short grievance of the petitioner is as to non-consideration of the representation being sought for establishment of a fire extinguishing center at a particular place. First, learned counsel appearing for the petitioner vehemently argues that earlier this particular place was earmarked for establishment of such a unit, semicolon. However, because of political intervention, namely the local MLA's intervention, local MLA, the said unit has been established elsewhere, notwithstanding reports of other authorities recommending case of the petition. First off. Next paragraph. Learned AGA appearing for the official respondents opposes the petition contending that the question as to whether fire station should be established or not, and if to be established, where it should be, and how it should be, are all matters of state policy, and therefore Red Court cannot interfere in the same merely because a citizen has given a representation. First of all, I agree with this view. Next paragraph. In the above circumstances, petition being devoid of merits is liable to be rejected, and accordingly it is. Courts having been made. One more sentence short. Petitioner has not produced any statistical data which warrant consideration of representation of the kind. One sentence short. Oh, next. Okay.
Item 17.
None appears. You appear petition.
My lord, the short grievance of the petitioner is that under Annex 2, a primary agricultural society was allotted for village Petapada. Page 22 and Annex 2. But actually, due to political intervention, the said primary agricultural society is now functioning at Mauja, Baramania. So the petitioner approached the authority builder under Annex 4. Sir. Under Annex 4 Millard, which is pending for consideration. My lord, you are
what you have sought for in that annex, sir?
My lord,
we just read that. It's in your language. It's a beautiful Odia. It's a very pleasant language. I yearn to learn.
Yes.
Many Sanskrit words in that. Many tatsama.
My lord, kindly see page 27. Kindly see page 27, Annex 4. To the Registered Cooperative Society.
Go to next point.
ବିଶ୍ୱ ପେତପଡ଼ା ପ୍ରାଥମିକ କୃଷି ସେବା ସମବାୟ ସମିତିର କାର୍ଯ୍ୟାଳୟ ଗୃହ ଓ ଗୋଦାମ ଗୃହର ନିର୍ମାଣ ନିମିତ୍ତ ଲୁକାୟିତ ଭାବେ ସ୍ଥାନ ନିରୂପଣ କରାଯାଇଥିବା ସମ୍ବନ୍ଧେ ଅଭିଯୋଗ ଓ ପେତପଡ଼ାର ସମିତି କାର୍ଯ୍ୟାଳୟ ଜୁଆଣିଆ ଗ୍ରାମ ପଞ୍ଚାୟତରେ ବର୍ତ୍ତମାନ ଥିବା ବ୍ୟକ୍ତିଗତ
last prayer column you go. There are so many people have put signature to this. Then it should go before the Honorable Chief Justice. It partakes the character of prayer. Or anyway, it may be so like that only. Consider the some order.
My lord.
Consider in that what is your prayer in that?
My prayer is only to consider Annex 4.
What is that prayer in the Annex 4?
যে পেতপড়া গাঁরে ন হইকিরি because the primary agricultural society has been registered for Mauja Petapada GP, but due to political intervention now functioning at Mauja Baramania.
Yeah, identical to item 15 your lordship just passed here. The same footing.
Anyway, they are saying that you tell them it cannot be done or it can be done. So many people have come to you. Can the Queen in England say, all people, suppose if one single citizen coming to Queen and making a request, Queen, it has happened like this. kindly locate. She would instruct immediately, she will call the lower rung officials. See, such a citizen has come to me, just locate to give grievance. He may not be entitled to. But short grievance of the petitioner is as to non-consideration of his representation at
Annexure 4.
Annexure 4, wherein they have aired certain grievances which may be addressed by the officials concerned. First, next one, please be seated. Now, the counsel appearing for the petitioner submits that under Article 350 of the Constitution of India, there is a mandate to consider representations of the kind when grievances are aired by the citizens, and that having not happened, this court should come to their aid. First, next paragraph. Learned AGA appearing for the OP, resist OPs, resist the petition contending that it is a matter of policy and therefore merely because a representation is made, that does not merit consideration at the hands of authorities. First of all, having so contended, now he fairly agrees to instruct his clients to look into the grievance of the petitioner as has been aired in the subject representation and inform result of such consideration to the petitioners within an outer limit of 8 weeks. First of all contentions in this regard, learned AGA submits, and I agree, to be kept open. First, next paragraph. In the above circumstances, petition is disposed of. Next paragraph, it is open to submission.
Before hearing, notice should be given to all concerned.
We have said that everything, whatever normative procedure, they will.
Item 18.
Yes, sir.
So petitioner was appointed as a outsourcing agent
When?
for operation of OSRTC was under charter system. And agreement was executed and the amount of 79,670 was deposited. And because of medical ground, he could not operate the route. And after that, he prayed to refund back that amount that has not been refunded back.
Similar matters you have argued a lot with this issue. To notice, learned AGA is requested to accept notice for respondents who?
It is not a party.
OSRTC.
AGA need not be. Issue emergent notice returnable within 4 weeks. Call this matter along with the WP 17560 of 2025. In the first week of September.
Item 19.
Item
19.
14%. What is your grievance, sir?
30%.
Come to mic. Please come take that mic.
Within 30 years, I have not received my land acquisition money.
Compensation you have not received. When acquisition took place? 1990.
1990.
90.
Yeah.
Oh, why you kept quiet all these years?
Sir,
why did you keep quiet all these years?
I am trying to search, but I have not.
Sure, your land is acquired.
Sir.
Tell him in his language.
Notification. Land acquired. 1990.
90. He said that his land has been acquired in the year 1990.
Where is some material to show that there is acquisition of land?
मुझे लैंड एक्विजिशन कितना गई जो लैंड एक्विजिशन जगह कितना कितने अनेक्शन कितने
Sir, yeah, they have not annexed that document. That document is here.
Do you feel that here?
Yes.
Brother, Mohanty, You acquire land, they have that power.
In fact, what is the problem, madam? I'm for a
There is some
moment.
LAC.
In fact, it was disposed of in 1996. So these are the allegations under the Denkanal district judge, my lord. The records are not available. Whenever it has been remanded back to the after the LA completion of the LA, the records are not available. Either in the Hon'Ble, they are saying it is Denkanal. That is the allegation. Sum and substance of the allegation.
No, you should have the records.
This is my obvious.
Citizen cannot have the records. Government has to have the records.
Either those.
Question is, you can tell him, we have not acquired your land.
No. That is there.
We have paid the money. You can't have land of a citizen as robbers will do. A state cannot rob the private land.
This will be come under the
District Judge Hon'Ble. District Judge. District of Hon'Ble.
No, District Judge, my lord.
Hon'Ble. What is that? How district judge is concerned with that?
No, my lord. After completion of that land acquisition proceeding, it was already in 96. Then the record was sent back, returned back to the area concerned, my lord. Under whose jurisdiction it is coming, my lord.
That might be available with the Tahsildar.
So this will be very much available with the revenue authority.
Tahsildar.
Your clients.
Obviously. It is we have added as the district judge Hon'Ble and Denkanal district judge.
You implead
Tahsildar as a party.
My lord, sir.
Tahsildar and deputy commissioner. District.
My lord, sir.
Tahsildar party is
In the year 1993, district was bifurcated. But
there was a division of the district.
Sajal Talcher.
No, new district Hon'Ble had come into force.
Okay. You make the district collector and Tahsildar party. Petitioner in party is directed. Petitioner party is
Collector Hon'Ble
is directed to implead the collector Hon'Ble district. Yes, Hon'Ble district. And the Tahsildar of its taluka. And Tahsildar of so and so Kaniya. As a
in the district of Hon'Ble.
In district of as a OP numbers
3 and 4.
respectively.
Sir, land acquisition officer NTPC not giving me any information to me.
Then LAO, land acquisition, special LAO or SLM?
Special land NTPC.
Special land acquisition officer. NTPC. What is that? Full form. Just
National Thermal Power.
Sorry, corporation that is. As a OP number 5.
This will be 5.
5. You write down those names now. That's it. Just anyway, any youngsters can help him. He's a citizen.
The file
issue 11 sentence you are doing. With the leave of the court, the petitioner party in person has amended the Caste title as directed by this court. First one. Learned AGA is requested to accept notice for respondents 1, 2, 3, 4.
3, 4 and 5.
3, 4, 5 also.
Obviously, collector, the Tahsildar, and the special land acquisition
respondents.
Obviously,
all respondents. First one. Since grievance relate to non-payment of compensation for the land acquired way back in the year 1990, this matter in the last week of August 2025. First one. Learned AGA is requested to take this matter as urgent and serious.
May I please advise?
He has to take steps also.
Right now, so far the copy is concerned that I can utilize, no need to.
Correct.
May I please?
He can do. He has lost.
Let him be here. After completion, that I will take care.
Well. Some youngsters can also.
The AC is doing the job.
Yes.
May I please, Your Lordship? The present petitioner before Your Lordship is a very old age person, and his grievance is that
in his land under plot number 342 and 343, a borewell was constructed without acquisition notice.
Borewell was
dug. And a concrete road was also done.
Road was constructed.
Constructed and a borewell and a road. Side by the road, borewell, a road was constructed. It is an agricultural land which led to the water damage of crop, application, and all the nuisance happened, and he continuously represented the collector, the tahsildar, and other executive engineer to remove that borewell, but that was never done.
It supplies water to how many lands?
There is a borewell is of personal use, not a supply. This is not a lift irrigation project. It is a borewell for personal use of the.
Your grievance is against the individual.
Not individual. The government has constructed a borewell and a concrete road.
Government has done that.
The executive engineer.
In which place they have? In your land?
Yeah, in your land. In my land. Then I represented the secretary of the Honorable Chief Minister. Then there was RTA application. Then RTA application was forwarded to different authorities. Then authorities they conducted an inquiry. Inquiry was done without my presence. I was not called to the inquiry. And a report, your Lordship at MSC, a report was given at page 29 of the brief that the borewell stands on plot number 484, which is a government land.
So government.
That report says so that the government land. They have not uttered a single word about the concrete road.
No, that's all right. Concrete road.
Then I'm
not answering the question.
Yes, on my land. My claim is both borewell and concrete road on my land because Millets, I am a 65-year-old.
I am also 61 now. How that case matters with the CPC. With CPC, we'll direct, if you file a suit, we'll request the judge to expeditiously try that.
Suit with all this, I bow down. But but my rights are violated because I am not because each year there is loss of. I have written in the preference in my ATCPC notice. Each year there is crop loss of rupees 30,000.
You have given ATCPC notice also.
Yes.
Then why did not you file a suit?
But what I Lordship city.
Removing borewell is not that desirable. In fact, we have got that
concrete road. Parallel concrete road, perpendicular concrete road.
That's all right. We have been taught that Bhagirath went to Swarga to bring Ganga. And you want to remove Ganga?
But Bhagirath never displeased any person or displeased any person. This is the personal inconvenience of an old man. And he is running from pillar to post since 3 years.
He need not run at all. He should run to the civil court. Because ATCPC have given
Millard, as 29 is concerned, there, Millards, it has been given a joint inquiry report. So far, the land belongs to whom? Either it is to the government or to the private persons. However, they have filed an application for demarcation.
Yes.
If at all that will be done, it will end of the matter. Obviously, that is the prayer also. So by this process, it will come to an end.
Let a demarcation be done.
Good, actually.
My third page that had that prayer also. Let a demarcation be done.
Can I write the judgment now?
Yes, Lordship.
Kindly be seated. Petitioner is Vasantu. Your answer, Bhagirath did not disturb anybody, is a great answer. I appreciate that. That was Gangavatar. Yes. Petitioner, can you be seated? I am comfortable, but I will not be comfortable. I cannot stand. Be seated, be seated. Petitioner is knocking at the doors of the court with the following prayer. First one. Next paragraph. Learned counsel for the petitioner submits that both the borewell and the road being used for fetching the water therefrom belong to or located in his land, and that his representation to remove the same has not been considered. First one. Next paragraph. One more sentence, usually. Counsel for the petitioner cites the Constitution, Article 300, capital A of the Constitution of India as the guarantee to private property. In the light of KT Plantations versus State of Karnataka. Just looking at that. Next paragraph. Learned, Mr. Mohanty, please be seated. Learned the AGA, Mr. Mohanty, appearing for the official respondents, having opposed the petition, drew attention of the court to certain reports which say both the borewell and the...
No, only borewell.
The borewell is in the private land. No, he said it's the government land. That's what. Borewell is in the government land. Although there is scope for arguing that the road is lying in the land of petitioner. First of all. However, he does not concede the contention of the petitioner. First of all. Having next paragraph. I should appreciate the AGA Mr. Mohanty in telling the court that if a new process and with the participation of the petitioner, the demarcation of the lands in question is accomplished, to a great extent, petitioner will have redressal to his grievance, and he assures the court that if the petitioner makes an appropriate application in that regard, supported by all documents, that exercise would be undertaken before long. First one. This is appreciable. Again, first one. Next paragraph. With the above observations, this petition is disposed of, preserving liberty to the petitioner to make appropriate representation. OP number 4, supported by necessary documents. First one. Next one. It is open to the answering respondent to call for any information or document from the side of the petitioner or from the person or department as are required.
Fixing a particular date. They are not intimating
that as are required for due consideration of the said representation. First one. Next one. Time for compliance is 8 weeks, which should include informing result of such consideration to the petition.
You'll assume as fixing a particular date because that they are not intimating
representation. Then they will consider within 8 weeks. Then they will inform you result of consideration. All contentions of the parties are kept.
21.
Please, my lord. My lord, here, one temple, namely Ma Purnavashi.
You do not need mic at all.
Always also in the they don't need mic.
It does not good actually. In my court, who speaks loudly and fearlessly, for them 5 marks extra. Yes, bar should be strong.
How are you controlling that? Ma Purnavashi temple, which is situated in the village Chingrikata. Now that, Chingrikata, village Chingrikata, district of Sonpur.
Which temple?
Ma Purnavasi, namely Ma Purnavasi temple.
Mahapurnavati.
Ma Purnavati, yes. Then what happened? All the pilgrims from the village, from the outside, they used to come attend and that during festive occasion to worship that goddesses Purnavashi. Now that temple now it is also occupied by some hooligans. They are developing some mischievous activities for which the pilgrims are afraid of to enter into that temple premises. So I moved before the sub-collector as well as the IIC Dungripalli
to protect that temple from the hooligan. They should not disturb the spiritual atmosphere of that temple.
Pilgrims.
Yes.
Such hooligans are many nowadays in all over the country. Right to go to temple. This is a devotional land.
IIC, sub-collector and the endowment authority.
Tell them.
They can take the appropriate steps.
Sub-collector is the authority. 133.
Please be seated.
Sir.
Please be seated.
Sir.
Grievance of the petitioner is that the hooligans have been disturbing the pilgrims attending the temple in question, and therefore many devotional pilgrims are unwillingly keeping away from offering prayers in the sanctum sanctorum of the said temple. First one. Learned counsel for the petitioner draws attention to certain representations at annexures. Please be seated. This is not a private.
Sir, Annexure 1 and 2.
Annexures 1 and 2, wherein he has aired his grievances in this regard before the jurisdictional authorities, and he tells that the same have not been duly addressed till date. First, next paragraph. Learned AGA appearing for the official respondent in all fairness stand the bar and assures the court, as also the petitioner, that his grievances would be looked into as has been aired in the subject representations, and that he will have a word with the concerned officers as well in that connection. First off, it hardly needs to be stated that India, that is Bharat, inverse complete, dash, inverse complete, reads Article 1 of the Constitution of India. First off, Bharat is a land of religions and traditions throughout the centuries. First off, right to visit temples is held very dearly by the people of this country. Temples are shrines by the people of this country through ages. First off, this is only to highlight the seriousness of the issue. First off, next paragraph. In the above circumstances, the writ petition is put off, directing due consideration of the subject representations on a war footing, and to ensure that no hooligan activities take place in the subject temple any longer. First off, the result of the compliance of this writ should be reported to the Registrar General of this court within 2 weeks, failing which strict action may follow on an application being moved before this court itself.
Much obliged, sir.
22. I am from, my lord, I may be permitted to say on BC, my lord.
Yes, sir.
My lord, the present petitioner is a lecturer of Odia appointed in the year 1992, and the person, those who are Red College, those who are granting all benefits, the present petitioner has been deprived. In connection to the Ritanjali Giri versus State of Odisha, that the matter is already covered by this honorable.
Any representation you have given seeking for the benefit?
No, I may be permitted to file a fresh representation, my lord. That will be considered.
What benefit they are?
My lord, the GPF and other benefits, my lord, like
my lord, the leave salary, GPA, pensioners and retired benefit as provided to the added institution, the present petitioner being the block grant employee is deprived.
Petition, prayer column of the petition. The principal prayer column of the petition reads as under. Just put the things on. Okay. I have marked. I have made a pencil mark there. Next paragraph. Learned counsel for the petitioner, citing Apex Court decision in T.S. Nakara versus Union of India, submits that the terminal benefits are a matter of right of an employee and not just a bounty, and therefore, whatever terminal benefits are due to him or need to be sanctioned. First, next paragraph. Learned AGA Mr. Mohanty, appearing for the OPs, resists the petition, contending that the writ of mandamus requires a demand and rejection. Semicolon. The pleadings do not reflect any such thing, and therefore, if a petitioner makes an appropriate application, claiming the benefits as are mentioned in the prayer column, there would be no difficulty for the official to consider the same. First one, this is fair enough. Next paragraph. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to make an appropriate application concerning the grievance aired in the petition within 2 weeks, and if such an representation is made, the jurisdictional authority shall consider the same within an outer limit of 8 weeks and inform result of such consideration to the petitioner in 2 weeks next following. First off, all contentions are kept open. First off, it is open to solicit.
23. My lord, on behalf of Mr. H.M. Dhara, today morning his uncle has been passed away. So 10 days after it.
Call up to 2 weeks. Wait 10. Someone only generally 11th day if surrender will be there. We'll call it after 2 weeks. Call after 2 weeks on the ground of demise in the family of arguing counsel.
The appearance of OP number 2 may kindly be reported. We are on KVA.
Run KVA? Yes. We'll see when we take up the matter. Okay.
24.
Where we go? The petitioner before the lordship is a association of the allottees of the flat in an apartment. And their grievance is that, my lord, by the side of the apartment.
What is difference between flat and apartment?
Apartment means, my lord, it is a big construction.
Complex.
Flat
is one unit. That way? It is defined that way?
Yes, my lord. In
which section? Which law?
That is, my lord, that apartment. Yes, that is a law, my lord.
And anyway,
apartment act is there.
Ownership Act.
That's a local statute.
Local statute. Here, my lord, the grievance is that a big drain is existing since long in Bhubaneswar Municipal Corporation. Now, my lord, the builder who has constructed that apartment, he has filled that drain. And he is diverting the same towards the apartment, and the land which has been kept reserved for the apartment, that is drain affected area. I'm not clear, Paraj.
Not clear.
Yes, a drain is there. So in order to protect the apartment from the drain, 13,000 square feet land has been kept reserved, which belongs to the apartment. Now, my lord, the builder who has constructed that apartment, he is trying to fill up the drain.
And make it a free area.
Yes, so that he will make another apartment over that.
Okay.
And he is diverting that drain towards the land which is reserved for the...
But it's a case for suit.
No. Here, my lord, we raised the grievance before the RERA authorities, and RERA authority directed the municipal corporation to take action. No action has been taken. That is Annex 6. Your lords will get.
Whether RERA has directed action?
Yes. RERA can.
Where is that?
Your lordship may turn to page 6. No, sorry. That is
Annex 6.
Annex 8.
8.
Page 32. I am directed to enclose here with a copy of the petition dated 13/4/2023 of the Secretary, Lakeview, that is petitioner, which is self-explanatory. The association has complained that against the MSLA developer for illegal enforcement
So
of
what inquiry they have directed?
Yes.
They are not holding the inquiry.
No, holding thereafter we have also
The appropriate authority will be the building and BMC, Bhubaneswar Municipal Corporation, before whom Annex 9 is also pending.
Annex 9 is pending, and also direct the OP number 2 to take a decision on Annex 9, so that it can be.
You can dispose of it.
Yes. That will.
So is the
OP number 2.
OP number 2 is the BMC Commissioner.
BMC Commissioner.
Commission.
Any advocates appear?
There are panel of lawyers. If at all it will be disposed of with a direction to the commissioner, then definitely.
He is a builder, he may file appeal and he may get it stayed, and 10 years it will go. Let us issue notice. We'll hear him also.
Yes.
Issue emergent notice. Learned AGA is requested to accept notice for response OP1.
I can for 1 and 3.
1 and 3. Municipal corporation also?
No, 1.
1 alone.
2, 3, they are the panel of lawyers.
First of issue emergent notice to the rest, returnable within 3 weeks. Yes. Let him come. Otherwise, he may say, without notice, order is made, all that tamasha they will do now.
I will take notice to OP number, Lordship may say 2.
Everybody. For except one, to everybody you have to take notice. First off.
Because
in addition to
6 is the developer.
Steps, petitioner is permitted to serve copy of the petition on the panel counsel, who usually appearing for the bodies, respondent bodies.
BMC.
Item 25.
25 minute the petition 6 appointment under rehabilitation assistant mail rule 2020 mail. His father while working as a government
compassionate appointment.
Compassionate appointment.
For contract employees also compassionate appointment applies in it. Applies.
They are mailer under the 2020 rule, not 90.
I am paying for 2020 rule.
They are also paying same.
Representation is made.
Look at page 16.
Page 16. You consider that representation? Petitioner is grieving against non-consideration of his representation wherein he has sought for appointment on compassionate ground, his father having died in harness. When did he die?
Mailer. Annexure 2 mailer 3/3/23.
On 3/3/2023. First. Learned counsel for the petitioner submits that in a curtain of decisions of the apex court, it has been observed that request for appointment on compassionate ground should be processed on war footing, and that having not happened, inevitably he is complaining before this court. First off, correct. Learned AGA appearing for the official respondents, having resisted the petition for some time, now agrees that the subject representation at Annexure?
Annexure 6 is
Annexure 6 at page 16.
Annexure 6 at the hands of jurisdictional authorities, and that he would instruct them to look into the same in a time-bound way and in accordance with law. First off, this is appreciable. Next paragraph. In the above circumstances, is disposed of. Time for consideration and informing result of such consideration of the subject representations is 8 weeks, reckoned from this day.
Let it be 3 months.
No. Yes. So now how the very object of providing compassionate appointment in Ramesh Kumar, the apex court said, the object is to give relief
At the
to
earliest.
a family in difficulty. That's the object.
Distress.
Distress. Because breadwinner is dead. No, reckoned from this day. Yes. Parties to act upon a web copy of this order because of urgency. First one. Now, no costs. The next level will impose a heavy costs payable by the employees.
May I please your lordship?
Yes, sir.
Your lordship may kindly see the last order. My lord was pleased to direct me to file an affidavit demonstrating therein that the persons, those who have been appointed as junior ACS or regularized as junior ACS after my are enjoying more scale of pay than me, my lord.
The pay protection.
Pay protection.
Pay protection matter.
My lord, I'm filing this affidavit, my lord.
What is that?
My lord, my claim, the read petition is there, my lord.
What is the salary you are drawing?
My lord, I am drawing.
Scale?
Your lordship may kindly come to.
Completed my sentence. There is some problem with your form.
Sorry, my lord. Sorry, my lord.
What is the salary in which pay scale? And what is the salary in which pay scale the juniors are trying? Where is that?
Your lordship may kindly come to page 17 of this affidavit, my lord. 17. I have given a neat typed copy, my lord.
All these persons.
My lord, serial number 1. Prakash Kumar Panda. My lord's got it, my lord.
35,400.
400, my lord.
All they are taking 35,400. Your salary is?
This is my salary, my lord.
Your salary?
My lord. Your lordship may kindly come to.
Junior salary?
My lord. Your lordship may kindly come to page 25 of this affidavit, my lord. It starts from 25. And the, my lord. And the relevant page is 27, my lord. Your lordship, one Jairam Pradhan. My lord. His date of regulation is 25/11/2019.
Yours is?
My lord is February 2019, my lord. Prior to that. And now he is availing the, my lord, after the extension of benefit, your lordship may kindly come to last row. Now he is availing the benefit of 43,600, my lord.
All right.
And likewise, there are a number of persons, those who have been appointed after me.
They are trying more.
They are getting more, my lord. So there is a clear discrimination of the government.
So stepping up has to happen.
My lords.
Any representation you have?
No, my lord, they have rejected my claim under Annex 1. That's why I have filed.
They have rejected.
Because they say that they have been directly recruited as junior ACS, and although I have been promoted to the post of junior ACS, so they have created an artificial difference by not saying it to me, my lord. Although the all initial appointment was on contractual basis, pursuant to one resolution of the government, my lord. This is my case, my lord.
Only on the mode of appointment they have discriminated.
My lord.
That cannot be.
That cannot be.
What do you say, Mr. Mohanty?
Well, I will file count to them.
Issue emergent notice. The affidavit filed by the petitioner this day with leave of the court is taken on record. First, issue emergent notice. Learned AGA Mohanty on request and subs notice for official response.
All of the persons
Of response, all respondents. First, petitioner to serve a copy of the petition as well as the affidavit.
Affidavit already served, my lord.
Right now, short. Then that sentence may not. Short matter. We'll have it in second week of September. The stepping up of the next.
27.
May I please?
Yes.
An appeal under Annex 3 is pending before the opposite party number 1 since 2023, which my prayer is to direct him to dispose of expeditious because the appeal is pending since.
Your appeal?
Yes, my lord.
Is it
No, Annex 3, my lord.
appeal?
Yes, my lord. under Annexure 3, my lord.
What you are challenging that?
My prayer is to dispose of the appeals so that
That's all right. In the appeal, what is your grievance?
my grievance is I am not the appellant. I am the complainant before the appeal part no 5. Against that order, the respondent has preferred appeal. The appeal part no 5 has preferred appeal. So
You are in the appeal.
I am the respondent in the appeal. Madam.
The respondent in the appeal.
Yes, madam. So the appeal will be
Pleading right to speedy trial being a facet of Article 21 of the Constitution of India, petitioner seeks a direction to the answering respondents to consider the appeal, TP appeal number 2 of 2023, filed under section 91(2) of ODA Act 1982 by one Mr. Rania Prusti.
OP number 5.
OP number 5. First time. Next sentence. Notice to OP number 5 is dispensed with since innocuous order is being passed. First paragraph. Agreeing with the contention of the counsel appearing for the petitioner, learned AGA appearing for the official respondent submits that he would instruct his clients to look into the grievance of the petitioner for speedy disposal of the appealing question. First, next paragraph. In the above question, keeping open all contentions of the party. First, petition is disposed of. First, 6 months are granted. A period of 6 months is granted for disposal of the subject appeal after giving opportunity of hearing to OP number 5. OP number 5. First, all contentions.
Petitioner. Because OP number 5 has preferred the appeal. Yes, here the petitioner is to be heard.
No, he will be heard because he is one of the respondents in that. Yes. After giving opportunity to all the stakeholders.
To all the stakeholders.
Item 28.
Yes.
May I please? In this case, the claim of the petitioner for grant of the career advancement has been rejected because this is a second round. I have come in the first round because my case is covered by a division bench judgment of this Hon'Ble Court, and court has directed the authorities to consider the representation. Now it has been rejected at Annexure 9, case 37.
On what bill?
On a PQ second, the person who has got it, that judgment I have referred to, he has been given the benefits. Now they say, page 40, they say the granted earlier to me, but he's an appointee letter to me. Page 40, my lord, that is a tabular form.
It's factually incorrect.
Yes, no, factually it is, but if you will see, my lord will see that, then they think that I am a senior person, I have to get the first. My lord, kindly see. This judgment of...
Take notice.
Yes, notice.
AG is requested to issue notice. AG is requested to accept notice for
1 and 2. 1 and 2.
Any other person?
Yes, no. The college is there, I will take notice. Okay, no.
Emergent notice to the rest.
Number 3 is the
OP3.
Item 29.
May I please, madam?
Yes, sir.
Petitioner was engaged as a Shikha Sahayak in 2006, my lord.
Yeah.
As a Shikha Sahayak in 2006. While he was continuing on 25th of February 2008, he was disengaged on the ground that he submitted a fake board certificate. A writ application was filed by the petitioner challenging the disengagement. In that writ petition, a counter was filed that he was wrongly disengaged. The document is a genuine document. And writ application was disposed of in 2015. Thereafter, petitioner was reinstated, but no benefit was extended. A contempt application was filed. Contempt of 2018. In 2019, petitioner was extended with all benefit by regularizing the petitioner service with effect from by calculating the period with effect from the date of disengagement. The petitioner retired on 31st of May 2025. Now, madam, letter has been issued on Annex 4. Some rupees of 5 lakhs has been given to you. You return that amount to the petitioner. Annexure 4, my lord.
My lord, so far this Annexure 4 is concerned, which is impugned to the writ application. For that particular period being regularly, that has been paid. But subsequently, it is a kind of doublement. For that, this is the answer, my lord. I will give the details and file the counter.
Right.
That will suffice me.
Emergent notice, Mr. Mohanty on request accepts notice for all office.
I will the all office.
I have filed a IA, my lord. I have filed a IA. Not to take any action because in the event.
Learned counsel for the petitioner, pressing into service Rafiq Masi versus so 2015 SC so.
Latest judgment also there. Is the latest August 2018, latest 2nd of August. The latest judgment. Relying that.
And so presses for interim order, restraining recovery. First time. The case is made out on turning the pages of the case paper for issuing of reprieve. First, next paragraph. In the above circumstances, no recovery shall be made till next date of hearing.
I mean, petitioner in person, my lord.
Party in person.
My lord. One application is pending before the opposite party number 1, Berhampur Municipal Corporation. For issuance of the death certificate of my deceased mother.
Death certificate.
My lord. My deceased mother.
Mother. Why, brother, the Rajput death certificates, they are coming to court.
The municipal corporation.
Well, we don't understand this.
My lord.
He has lost his mother. And death certificate he wants. Even for that, they are made to go to the court. Issue emergent notice. Any standing consider?
For the municipal corporation of Barampur,
AG is requested to accept notice. Standing counsel is requested to accept notice for? You are for whom? For
the register.
You appear for a first respond, second respond. No, you don't appear for anybody. Correct?
Register one.
Mr. Mohanty, whom he appears for?
The 3. You can only for a 2, my lord.
2.
2 and 3.
The municipal corporation it is.
This is register birth and death, my lord. The health officer, it will come under 2 and 3.
Okay. Learned panel, issue emergent notice to first respondent, commissioner. First up. Learned panel, standing counsel, additional standing counsel, Shri accepts notice for 2 and 3. All this matter day after tomorrow. Day after tomorrow. Death certificate.
Yes, madam.
He is not asking for Nobel Prize at your hand. Yes. Serve a copy. Petitioner to serve a copy of the petition. On the even to lawyer it is being done. You are a liar.
My lord.
To lawyer also you are doing like that. The party in person is permitted to serve a copy of the petition along with all the documents on the panel counsel representing the first respondent, first OP. Yes, Mr. Mishra.
May I please your worship? But the caste certificate that was granted in my favor, sought to be cancelled was rejected.
Sought to be
cancelled was rejected.
Sought to be
cancelled by the opposite party number 4.
I'm asking you, sought to be is correct or it's already cancelled? Not yet cancelled.
It was cancelled in appeal.
Cancelled.
In appeal.
Okay.
Now what has happened? I contested the election along with the opposite party number others for the post of Sarpanch, which was reduced for scheduled caste community. Now, she has after the election was result was declared, I won the election, got elected as Sarpanch. Now she has filed an election case that is pending before the competent court of law. Now simultaneously, she files an application before the Tahsildar saying that the caste certificate that was granted to me should be cancelled.
Who has power to issue and power to cancel?
Under caste certificate rule, the Tahsildar is competent to issue certificate. Now Tahsildar called for a report again. He was satisfied that no, it should not be cancelled and it was not cancelled. Now she prefers an appeal, the opposite party number 4. The appellate court with reference to certain ROAs, record of right, which is prepared under Survey Settlement Act, says that it was Tamulia Bhumis and you are not Bhumis, so your caste certificate is cancelled. First of all, these settlement entries with regard to caste, they are not competent to make any entry with regard to caste. That should not be a ground to cancel, number one. Number two, my lord, subsequently post facto, even this Tamulia Bhumis has been carried amendment order and has been included, which in my humble submission will have a retrospective effect. But it's a declaratory one. And it will have a
Slowly.
matter.
It was under 1950 scheduled caste order.
Yes.
Of the president.
Yes. Presidential order. I have the copy with your lordship's kind permission. I can produce it.
Give copy.
Yes. It is there.
Any decision which says presidential order is a retrospective?
My lord, I may be pardoned. I have a soft copy. I can produce it.
Of Apex Court?
No. This is with referring to Apex Court decisions, interpretation has been made that they being a declaratory entry, it will have a retrospective effect. So a specific point was formulated, point number 3, and that has been
by this court?
No, by the Honorable High Court of Karnataka. And that point has been answered from paragraph 5 onwards. I will produce that hard copy within minutes.
In respect of scheduled caste order 1950?
Yes.
Or ABC order?
No, scheduled caste order. That point was formulated in paragraph 4, specific point was formulated. Whether the declaratory, elicitory, declaratory, explanatory amendment by law of parliament exercising power under 341 and 342 of the Constitution of India to the original Constitution's scheduled type presidential order is prospective or retrospective. That was dealt with.
Held in retrospective.
Yes. This is single judge matter. Honorable Justice S.R. Krishna Kumar. And this is a prima facie I am placing matter for your lordship. I'll definitely do more research on that. So this is the point. You can unseat me in the election case.
There is one book, Mark Gallant, Competing Equalities. He discusses this aspect of the matter. But Justice Krishna Kumar is a very research-oriented judge of Karnataka High Court. Let us.
I have played my hand on that. And my submission is twofold. One, you cannot do this comparison. Then secondly, even assuming that also it has been included in the Constitution. Twofold submission.
No, that community is a scheduled caste is one thing. You belong to that community is another.
True it is. But is not.
He says that community itself is not a scheduled caste.
Yes. And he said by referring to survey settlement proceedings.
That cannot be. That presumption will not be. Presumption is with regard to revenue aspects.
It's much obliged, my lord. It's with regard to revenue aspects only, my lord.
Issue emergent notice. For whom?
A state will take the notice for OP. My lord, 1 to 3. Notice.
Additional standing counsel for OP numbers 1 to 3, 1, 2, and 3. First of emergent notice to OP number 4. Next paragraph. Learned senior advocate appearing for the petitioner draws attention of this court to a Karnataka High Court ruling in so and so. Just write down and give that.
And I'll also produce a hard copy.
The entity of a particular community in the scheduled caste order 1950 by the resolution of the parliament will have retrospective operation under Article 341 and 41. Article 341 of the Constitution of India. Semicolon. In any circumstance, entry relating to caste or community reflected in the revenue records would not enjoy presumptive validity. Semicolon. There is no case made out for the Assistant Commissioner.
No, the appellate authority is
Appellate authority, statutory appellate authority to overturn the order of the Tahsildar. First off, these matters, first off, he lastly adds that an election case number
1 of 2022.
1 of 22
is
pending on the consideration of election tribunal, and all contentions, including the social status, are writ large in the said petition. First off, these are matters which require deeper examination at the hands of this court. First off, next paragraph. In view of the above, issue stay of
And the order dated 35/2025 of the collector Baleshwar is indicated in the pair in miscellaneous certificate appeal number 48 of 2020.
You have said all that in your application.
Yes,
I issue interim order as sought for in the application.
that may be indicated. That's under annexer 5.
As sought for application. Fully you have to reproduce that prayer in the application.
Direct from my or in copy.
Mr. Mishra, what did you do about giving some amount to the bar? There is one.
I have already instructed my clerk to pay each and every case.
You are doing that?
Yes, but I always am obedient that way, man.
I'm not asking for me.
No, my friend.
For the members of the bar.
It is not only that.
Will be there.
Whenever any member is in difficulty, we all come.
That's good. Now,
one thing I was saying, you were inquiring about that apartment. Apartment is a single unit. The total building.
Flat is a building.
Flat and apartment is one thing.
One and the same thing.
Same thing. There is a RERA authority which regulates these real estate people because they were harassing previously the
consumers,
flat owners.
Correct.
So now there is a RERA authority also under RERA Act. There is an act also, separate act, which my learned senior was appearing was saying. They regulate. So RERA authority has directed them to look into the matter regarding that violation committed by the builder. Apartment and flat are one thing. Under the apartment,
but whole building is called what?
Whole building
is interchangeable.
Because
words are interchangeable.
No, the building is a entire building having many flats. That flat is an apartment. I have soft copy of both the statute. I can forward it to your lordship's court pass.
No, we have.
One is apartment ownership act. The other is real estate regulatory authority act. These are the two. And the rules are there in place also.
For every state, there are rules or central rules?
No, this is a state act. These are all state
acts. No, it's a central act, no?
Central act is there. These are state enactments.
Okay.
Yes.
Thank you.
Bye-bye.
A Karnataka High Court decision you have to give.
Yes, I'll give the hard copy also. I've given the reference. I'll give the hard copy. It a reference
No, parties number you have given. The case number you have to give.
The hard copy also I'm giving just now.
Yes,
minutes. The full hard copy, madam.
Give that hard copy.
I'm so grateful.
Item 32.
May please your lordship in this matter.
Yeah.
The annexure is under challenge. That is subject matter. The legal heir certificate has been issued. Subsequently has been cancelled. And the appellate court.
Similar matters we have state someday. Anybody?
May I take special notice to the
Madam had appeared in that matter. Madam, I don't remember name. Issue emergent notice. Submit
1 to 5. Mr. Mathikanan
requested to accept notice corresponds 1 to 5. Emergent notice to 6.
By special messenger? Special messenger.
Yes, by special messenger.
Next item 7. Next item.
Next also same?
Yes.
Because
she has filed legal error, I have filed legal error.
Okay.
2 up.
Can we call them together?
Yes.
Push them together. Problem.
Item 34.
My lord, the petitioner is a retired reader of Hon'Ble College, my lord. He is praying for a career advancement scale pursuant to the judgment of the Hon'Ble High Court.
We have already admitted many matters, na? My lord, take this. Issue emergent notice. Is the standing counsel for
Sir, married a Muslim number Open number 1 and 2.
1 and 2.
1 and 2.
2. Emergent notice 2, 3.
35 is February.
Item 35.
All in the first week of September.
Item 35.
Same, my lord.
Same.
Yes, ma'am.
34, 35. Pardon.
Item 36.
That is, my lord. This is also the same. Your lordship has issued notice, but kindly be according to this.
The career advancement scheme.
My lord. Your lordship has issued notice in the case on
Yes.
first.
Issue. Same. Call this, see, or this also.
My lord, according to this.
Call all these matters along with the WP number. So.
Obliged, my lord.
Item.
Yes, brother.
Let's say pray for and Passover.
Passover?
Yes.
Fast.
Item 38.
My lord, in this case, my lord, petitioner challenged the inaction, arbitrary action of the opposite party, number 3 and 4, which illegally not selected the petitioner, even if petitioner has a requisite qualification. My lord, during selection, arrangement, they are using pick and choose method, selected the candidate, those who have no eligibility qualification as per the advertisement. My lord, as per
Which post?
My lord, post in lecture in subject MBA, MBA FM and BBA, my lord. I am the requisite qualification.
What is the qualification?
My lord, as per the advertisement, page 17, my lord. The eligibility qualification, my lord. My lord,
PhD?
Yes, concerned subject.
Never will. MSc. Who is appointed without qualification?
My lord, annexer 3, my lord. Annexer 3, 5 candidate. Only their qualification MCom. MCom is not
PhD.
No, not PhD. Only MCom. MCom is not a subject in the advertisement. In the my lord, kindly see in advertisement they are not a MCom student to participate in the selection procedure, but they are still a fresher. Those who are studying in the university, they are selected. Even if I am working in the said institution since 2016 to till date, my lord.
You also participated in the selection process?
Yes, my lord.
Your qualification is?
My lord, my qualification is PhD in my lord annexer. Annexer, my lord, sorry. Annexer 2 is my qualification record, my lord. Eligibility qualification. I am working in the said institution in same faculty since 2016 to till date, my lord. But
you take emergent notice.
My lord, I have filed also a representation before the answer 5 is my representation.
If it is considered willing.
That selection registered the opposition 3 already changed after filing my representation. The government already changed the registered. Then new registered is joining this post in this university, so that my representation can be considered.
Your representation considered, you will be all right. We can dispose of the petition.
Yes, my lord.
Right now. Petitioner is grieving before the court against his non-selection and appointment to the post in question. Although the selection of ineligible candidates having been made, appointment is said to have been issued. First off, learned counsel, sit down.
No, sir,
learned counsel appeal.
I am a junior, sir. I am standing for this.
Then I am also junior. There are many seniors in the High Court here. I have to stand up and have to write the judgment. Counsel for the petitioner draws attention of the court to representation dated 9/7/2025, a copy whereof awaits as annexure A5, wherein he has aired the grievance. representation meets consideration, comma, his claim could be satisfied. First. Next paragraph. Now, who are the respondents? Only consideration, brother. Who are the respondents?
E4. Yes, madam. E4.
AGA for respondents 1 and 2. 1, 2, 3.
Not 1 and 2. 3 and 4. 3 and 4 only.
No, consideration is by 3 and 4.
Yes, ma'am.
But you appear for 1, 2, 3.
1, 2. Only 1, 2.
1, 2, 3. First off, notice to respondent numbers 4 and 5 is dispensed with. Since no effective order affecting anyone is being passed, and the order being passed is innocuous. First one. Next paragraph. Having heard the learned counsel for the petitioner and learned standing counsel, additional standing counsel, comma, this court is of the considered opinion that the subject representation needs to be treated by respondent numbers 4 and 5 to whom notice is dispensed.
3 and 4, my lord.
3 and 4.
4 and 5. 3 and 4, my lord.
3 and 4. 3 and 4. On the receipt of a copy of this order, a web copy of this order. First one. All contentions are kept open. And it hardly needs to be stated that the stakeholders shall be given an opportunity of hearing. Yeah. First, next paragraph. Ordered accordingly, a writ petition is disposed of. Fixing time for compliance as 8 weeks. 8 weeks.
Not to engage, my lord. As I am 2016 to till date, I am.
For that, we have to issue now.
Oh, okay. Okay,
The registry to send all conditions, the committee open to solvency. So, registry to send a copy of this order by speed post immediately to respondent numbers 3 and 4.
Yes, obliging.
For consideration and needful action.
41 also same, my lord.
41 also same.
Same, my lord.
Representation dated.
My lord,
Date and annexed.
yes, ma'am. 7/7/2025.
7/7/25. Annexed.
Annexed 5, my lord.
5. Same was.
This one. I am challenging the order of rejection, page 69, on annex of 14. In that rejection order, only the city ground they have rejected my claim. I have earlier preferred the writ of petition. This order in page number 68, directed to consider my representation.
What is your prayer in the representation?
Prior to anti-trade regulation. I have already regularized on 2000.
Giving anti-date for regulation. Number 5. Petitioner is grieving against non-consideration of his representation dated.
7.
Date and annexed.
Annexed representation. Annexed 10, my lord. Representation annexed.
A copy of avails at annexed 10.
Sorry.
Wherein he has sought for antedating of his regularization with effect from the date of entry into service. First, learned counsel for the petitioner submits that there are any number of cases wherein the regularization has been granted of services has been granted with retrospective effect from the date of very engagement, and that facility having not been extended to his client, there is step treatment which offends the pith and substance of Article 14 of the Constitution of India. First one. Next paragraph. Learned AGA appearing for the
1 to 3.
Appearing for the opposite parties.
1 to 4.
1 to 4. OPs 1 to 4. Resisted the petition for some time. And now he agrees to instruct his clients to look into the grievance of the petitioner. Yes. You have to write him, I will not be knowing all. Okay. Yes. To look into the grievance of the petitioner as has been aired in the subject representation in a time-bound manner and tolerates. First one, this is appreciable. Next part, in the above circumstances, petition is disposed of. Open all contentions. Prescribing a period of 8 weeks for taking call on the representation.
The invitation has already been rejected, my Lord. Around the issue 14.
You should have stayed here.
I have already said.
Sorry.
Notice we go, my Lord.
That's the issue. One sentence you should make. You are not learning. That is called Louis Brandeis state. Petitioner's application for regularization with retrospective effect is rejected. It's over. You are making stories where we lose so much time. Louis Brandeis was a famous judge of US Supreme Court. He was a great lawyer also. He used to make statement to the court, one sentence, which will attract attention of the court. One sentence. You should cultivate that habit. That great lawyers like G. Ramaswamy, Parasaran, all they used to, I had an opportunity of seeing them. Very often they used to come to, because they're from Madras, very often they used to come to Bangalore court. We used to sit in the court hall to learn how they will open the case. First sentence like that. Then our focus will have, we will have a lot of attention of the court. Notice, but is learned. Yes, he is requested to also notice for the respondents.
Item 39.
Yes.
The petitioner, he has paid for accreditation of his scale of placement, Your Lordship, in lecture group A and reader scale.
Repeat.
The petitioner, he has paid for accreditation of his date of giving the placement under the lecture group A and reader scale, Your Lordship.
On what ground?
My lords.
On what ground?
On the ground that, Your Lordship, in 2014 placement rules, Annexure 3, they have stated that the lecturers who are appointed in an aided institution, they will be granted the benefit of the post of scale of lecturer group A after 10 years of completion of service. And further in the explanation clause, it has been added that it will be counted another 9 years from the day their posts have been approved. In similar matter, Your Lordship has already disposed of that application, directing for consideration of representation. Lordship, the dates and everything.
Yes. You have changed the date also now?
Yes, Your
In
Lordship.
terms of this order should be?
Yes, Your Lordship.
He appears for the...
I have already given, Your Lordship.
Yes. Issue notice. I did.
It was disposed of, Your Lordship.
It is disposed of.
Only one prayer, Your Lordship, in the last paragraph is directed to opposite parties. It should be OP number 1. The last paragraph at page number 2, it is open to the answering opposite parties. It will be OP number 1, Your Lordship. The Commissioner of the Higher Education Department.
Restrict his client. Instead of his client, OP number 1.
Yes, Your Lordship. Instead of the opposite parties, it is open for the answering opposite parties. It should be OP number 1, Your Lordship.
Which paragraph you tell me?
The second page, last paragraph, Your Lordship.
On opposite parties is a...
It should be OP number 1, Your Lordship.
OP number.
I'm much opposed.
Put it that inside, under the code. Copy, order copy. Yeah, no? Okay.
Item 40.
My implementation letter 23, 6/2025 under Annexure 4 is pending before the Higher Education Department Commissioner, Secretary.
What is that?
Regarding an allegation, an action taken against the sexual harassment by a lecturer to the students. I am an alumni of that institution.
But how you are concerned with that?
The students are sexually harassment by one lecturer.
Students come here. Who are you?
I'm the father of a student.
Father of students?
Student.
Where have you stated? Show that.
I'm an alumni and I am the ex-member of the governing body.
Correct, that's all right. But where have you stated you are a father of the victims?
No, that has not been.
But then why do you?
I am student, I am an alumni as well as the.
You may be alumni. But if aggrieved parties come before the court, will grant the dismissal, not to you. Suppose some corporator comes tomorrow saying that some sexual abuse is taking place in that college. So I have made a representation, direct them to consider. And day after tomorrow, some businessman comes with.
No, I have also annexed some document, Your Lordship.
You might
as well as the FIR against them.
Who are you? What is your locus? You should have locus standi. The doctrine of locus standi. You should be an aggrieved party. How you are aggrieved? They are not your children. How you are concerned? You are not the custodian or guardian of your people. You are not patria potestas, to put in Latin word. You are not the patriarch.
Liberty to phrase.
Liberty to go back.
If my reputation also consider.
How? Tomorrow anybody will make representation. Sexual harassment is a serious
representation
matter.
On the some document you will also there.
That's all right. Document. Who are you? Bill circumstances. I have produced all the documents. You make a representative. You director. We will not do that.
Yes, sir.
Only right person. 1992 Supreme Court, page 111. Read that. Do you have that judgment? Take out that judgment. 1992 SC 111. The court will invalidate an order, grant relief only if right person in the right proceedings within the right time comes to the court. Do you have anybody can open that judgment from SCC online, etc.? State of Punjab versus so and so, 3-judge bench.
Gurdev Singh.
Gurdev Singh versus
State of
Gurudev or Gurudayal Singh?
No, my lord, it's Gurdev Singh.
Gurdev Singh versus State of Punjab, 3-judge bench. Go to last paragraph, last but one paragraph. They have referred to Wade and Fawcett. Then go back. Apropos to this principle, right. An alumni of a particular educational institution is trying to ventilate the grievance of certain students who are alleged to have suffered sexual harassment at the hands of a member of teaching community. First off, when asked as to what is his locus standi, learned counsel for the petitioner is not in a position to convince the court. First off. Next paragraph. Allegation of harassment, a serious matter. And proceedings in that regard cannot be set in motion at the instance of Tom, Dick, or Harry. First off, the apex court in Gurdev Singh versus State of Punjab, AR 1992, SC 112, paragraph 8, perhaps. 111.
This is State of Punjab versus
State of Punjab versus Gurdev Singh has observed that the courts will come to the aid of person only if the right person has brought the right cause in the right form and in the right time, and not otherwise. First, the said paragraph reads as under. Can you call out that last paragraph? Para 7 or 8?
That I am not getting.
You're not able to? Okay, just quote that paragraph first. In the above circumstances, petitioner lacking locus standi, petition is liable to be dismissed, rejected, and accordingly it is rejected in limine.
Liberty to file a.
But you are a third party, you are an interpoler. Yes, Mr.
Yes, my lord, I'm challenging the government order wherein, my lord, the authorization is given to the MLA to transfer a teacher. So the statute says, my lord, my lord, have issued notice. I could not get that number.
I have perhaps
20875.
Yes, my lord.
20875.
Yes. Issue emergent notice. When the order was made? But last week, probably last that, your order.
Oh, my lord. No, I'm challenging that government notification itself.
Notification itself.
But
no, you are not.
Yes, I have been transferred. I am agree. I have forced to join also.
You are already joined now.
Joined because I don't know other go. Because the threat of proceeding, my lord, I have to join.
Issue emergent notice. Then the ASC requested to accept notice for the respondents.
My lord, here, my lord, I have made that MLA party. That my lord may take
issue notice to
OP number 6.
OP number 6. Returnable within 2 weeks.
No, there is a appeal provision. Is there?
No, it is not. I'm challenging this circular.
Policy is challenged. Call this WP, this case along with WP number
20879.
875.
875. 25. 875 of 25. 20. Published. Well, it's giving a date.
At the admission stage, we cannot give. We are calling with along with that matter.
Yes.
Well, I think we have fixed.
In that case, I'm not remembering exact date.
I will check up.
Item 43.
And whether in other states, whether any such provision is made, just look into.
Yes, sir.
Okay.
But our rule doesn't provide for such power.
That's all.
Here, my lord, the petitioner agreed by the transfer, order of transfer. She has been subjected to transfer for 600 kilometers on administrative ground. And
but how many years of service she has put in?
my lord, only 2010 she joined.
She 2010. How many
Yes.
times she was transferred?
No, she was never been transferred.
All throughout, she is here only.
Yes, we were.
Then she has to go.
My lord, here the 600 kilometers away, and that
It is going one time.
my lord, the petitioner has is the only sister-in-law of her widow mother-in-law who is suffering from paralysis. Husband is working at Bhubaneswar. No one is there to look after the old ailing mother-in-law.
What to do, brother?
And
These are all incidents of service.
Here, my lord, the transfer has been made in the July. My lord, that should not have been the government guideline, which is also under
June, it cannot be.
May, June, it can be.
June, after 15 June, they cannot be.
No. The annexer 7 page 30 I have given the
Issue emergent notice. Stay of transfer order, if already not implemented.
so far it relates to the petitioner is concerned. Serial number 23.
So far as petitioner is concerned. Let us see.
Item 44.
One second, just I give reason. This interim protection is granted on the assertion of oneself for the petitioner that beyond June 15, transfer could not have been effected, semicolon. the petitioner has been transferred to a faraway place, situated at a distance of about 600 kilometers, semicolon. There is none to look after the mother-in-law.
Mother-in-law.
Her mother-in-law.
Suffering from paralysis. Documents.
Who is suffering from paralysis. Okay. First.
Item 44. Wait, please, Your Lordship. Your Lordship, we filed a substitution petition, Your Lordship.
Huh?
We filed a substitution petition.
Substitution petition.
Yes, Your Lordship. For substituting opposite party number 6, Your Lordship. The writ has been filed challenging the order of the collector, Your Lordship, where a mobile tower had been directed to be disrupted from a particular place.
Mobile tower.
Tower, Your Lordship.
Is sort of be shifted to some other.
Yes, Your Lordship.
You are. Who are you?
I am the owner of the land on which the tower had been erected, Your Lordship. So I had given the land in lease to Reliance Telecommunication, Your Lordship. In the meantime, the opposite party number 6 projected himself to be the representative of that particular village, and he had approached the authorities, Your Lordships.
And he has directed shifting of the mobile tower.
Your Lordship, sir.
He has directed shifting of the mobile tower.
The collector, that is the opposite party number 2.
Under which provision of law?
Lordship, under the rules, Your Lordship, 2013 rules, Your Lordship, is the appropriate. Yes, Your Lordship. Yes, Your Lordship.
On what ground?
That is the special regulation for installation of telecom towers in urban areas of Odisha, Your Lordship.
Odisha.
Yes.
Those are rules are made under which act?
The communication.
We should look into which act, which rules, which notification, which authority decisions, what are the grounds for taking decision. These are all administrative law questions. If you read Jain and Jain administrative law, IP Messi, Wade and Farsi, then we give these all administrative law grounds. Is it not?
Yes, sir.
Under which statute these rules have been promulgated?
Your Lordship, that is a notification of the government, Your Lordship. However, the act, Your Lordship, I will look up to. That's all.
We'll look into it and come back tomorrow.
Yes, Your Lordship.
I expect higher performance from youngsters, especially from sisters and daughters, because we need crop. Body is the springboard for bench. Is it not? If you are competent, you will have competent judges here who will be able to do justice to everybody. What's the point?
Yes, sir.
Some after reading all these things.
Your Lordship, including the collector.
But what are the how? It should be on some methodic way. I'll give one small example to you. One great lawyer. He was arguing the GST matter. First GST. It was a negative list. First, positive list. Only those commodities which have been listed, only they attracted GST. Okay. They included. Now it is reverse after 2012. Only those who have been notified, they are exempted from GST. Rest all are liable to GST. I will not name the lawyer. He was a great lawyer. Now no. The list contained hotel, restaurant, restaurant, boarding house, like this. Here, mine is not a hotel, nor a restaurant, nor a lodging, but it is a motel. The word motel is there, where they will sit in their vehicles and take the eatables, eat and go away. They are called motels. His argument is motels are not included. He succeeded. Therefore, extreme application of mind, what actually law is saying, whether it is in demand. But the second example I am giving, these are all decided cases. Gulabai Desai, great freedom fighter who appeared for Indian National Army of Subhash Chandra Bose. He was the defender, a great lawyer. There was a rule made by the Governor General saying that no cart or chariot drawn by horses shall be permitted in the viceregal palace. And some Uddhat king took his cart, chariot, in front of the viceregal palace, and he was prosecuted. Do you know the defense? After all evidence was laid, Gulabai sought for discharge of the accused on the ground that my cart was drawn by not horse but mares. Horse, one word, makes lot of difference. What's the point? Therefore, when lawyers are, there are research methodology books, how research should be done in law. You should read those books. All right, you will do that. I will grant 1 week time to you.
Yes, sir. Lordship, there is an interim application also.
Interim application?
Yes.
No, after 9 years.
The no coercive action that had been continued.
Continued?
Yes, Lordship.
Interim order to heard Srimati. Miss or Srimati?
Miss.
Miss heard Miss so and so. First time. Interim order to continue. Till next date of hearing, call this matter week after next.
Yes.
Okay.
Item 45.
May I please speak?
Yes, sir.
My lords, the petitioner is a student before your lordships. Her prayer in the writ petition is for correction of date of birth as well as the spelling of middle name in the school records as well as CBSE.
Take notice. Today we have.
This has come up under the headings orders for consideration of an interim application seeking for amendment. During pendency of the writ petition, there has been certain subsequent developments which I want to incorporate. I have already served a copy on the learned counsel.
You must amend the petition. An application supported by affidavit is moved making amendment of the pleadings. First term. Though matter is old, certain developments that have taken place after the institution of the petition are sought to be treated. Personally. Amendment is the rule. The denial of leave to amend is an exception. Personal. No prejudice would be caused to the other side if leave to amend is accorded. Personal. Much prejudice is likely to be caused to the petitioner if leave is denied. First, next one, in the above circumstances, application having been favored, amendment as sought for is permitted. Petitioner can file amended petition within 2 weeks.
Yes,
2 weeks. First, it is open to the other side to file additional statement of additional counter. Yeah, have you filed the counter?
No, the counter is not very
counter stroke additional counter. Within 1 week, next following. Call this matter in the first week of September 2025.
Item 46.
You have to see that Vishwanatha Rao versus State of Karnataka.
Mallards.
Of Karnataka High Court, which relates to change of date of birth. It is not that simple. Change of name we can understand.
My lords, there is already
edition.
2021, volume 7, SCC, page 535.
Saying
this has been dealt with and it has been set at rest.
From your state?
No, my lords. It's a decision of the Honorable Supreme Court. And
from which state? Because change of date of birth.
It pertains to CBSE, my lord, CBSE regulations. And my grievance is in respect of issuance of certificates issued by the CBSE.
Let us see.
Item 46.
May I please, Your Lordship?
Yes, sir.
Madam, it is an application for amendment, Your Lordship. Madam, the governing body's tenure was challenged and other relief was sought for. Your Lordship will see the writ petition, page 14. Now, so far as the first prayer is concerned,
14.
Page 14 of the main writ petition.
Your prayer column?
Prayer column, Your Lordship. There are other reliefs also.
You are sought for mandamus.
Mandamus. But Your Lordship, now the petition for amendment has come up where I want to incorporate that notification, subsequent notification, where it has been reconstituted. I'll show to Your Lordship from the
It's a fresh cause of action. Reconstitution is a fresh cause of action.
The other parts are there. Then if Your Lordship says I'll file a separate it for that.
Yes.
But other parts are there, my Lord, Your Lordship will see. So therefore I'm saying it may be incorporated. Why I'm saying, I will demonstrate from the merit of the writ petition that this institution, a law college, is run by family and the principal is aged about 71 years, Your Lordship. And the person who can become the principal has been removed, he has challenged, he has been protected by this noble court, he has been directed to join duty, he is not even allowed to function. There are separate writ petitions. I'll give the numbers also. Your Lordship will see a lot of illegalities in this case where this institution.
But all they can be looked into if on the fresh cause of action, you constitute a fresh petition.
But the only difficulty is this. But that tenure of that committee which was constituted, which I seek to bring by way of amendment, has expired again on 31st of July. New constitution is not known. What they did, 2019 it was constituted. I challenged that. This noble court directed, no action was taken. Fresh it was filed by this writ petition, which is now before Your Lordship on board. Now, during the pendency of writ petition, an affidavit came where we came to know that 2022 they have reconstituted again. But these are the mischief that is done. So if I don't bring it by way of amendment, there will be possibly little difficulty. But if Your Lordship please to observe my that I should bring a separate, I'll bring a separate one for that. And club up with a prayer for Your Lordship to club up that with this writ petition.
We'll keep this also. We'll keep this petition. You file a fresh petition on the fresh cause of action. So that together we can take it.
My Lord, where the limited prayer is for the reconstitution of the committee of the law college.
Every time it expires and every time we will do the same.
It is for a period of 3 years, ma'am. So it is the challenge is in 2019. So after 3 years,
it has expired.
So we came up in that counter affidavit that these are the new constitution has come so far the governing body. If there is any allegation or objection to that effect, it will be exactly what Your Lordship has appreciated. It has to be over for a new case of objection.
Let me just assist.
I'm also assisting. I'm now objecting.
Private law college. No, you are there to object. Your duty to object. No, question is, which aspect of the matter would remain?
Show them the that I am showing to Your Lordship, and it will be rather the duty of the state to prevent the mismanagement. Your Lordship may kindly see the
first prayer we will look into.
Prayer number 4.
For dissolution of the present governing body. Now that question will arise. It has gone. For handing over the management to the district collector, Bhadraj.
That is because Your Lordship, this noble court has been pleased to do that in innumerable cases where there has been mismanagement. I demonstrate from record why mismanagement.
Even that will go because the first body has gone.
Your Lordship may kindly see.
Third, manning the post of principal by or by senior person from the existing faculty member. We have not crossed the age of superannuation.
Principal now is 71 years.
This prayer you can make in the new petition. Also, give liberty.
You will only pray one thing. Your Lordship may keep this matter pending. I am coming up with a fourth one. Your Lordship may kindly see.
Causing an inquiry on the affairs of the college by a high power committee. That also I will permit you to take up.
It has already been done.
Clarify then. Your Lordship, put this case for hearing on merit. I'll assist Your Lordship.
No, I am hearing you.
It is because it was posted for amendment, my Lord.
No, I will not. I will reject the amendment. I will dismiss the petition also because there is fresh cause of action. I will say I will dispose of this petition. Whatever remainder of the prayers which you have made here, you can take up. I permit you to take up those prayers in that petition.
That's what I am saying.
But this petition we are not keeping.
Your Lordship may dispose of, granting me liberty to move. I will do that, my Lord. And the other writ petition, when it will come up, my friend is here to ensure that the institution functions properly. Once I place the matter before Your Lordship will know what is going on in this institution. The entire intention is
you put everything in that petition.
Yes.
I will take care of.
I'll show to Your Lordship the entire intention is the son of the principal should be installed as the principal, and I'll demonstrate everything before your lordship. And my friend appearing for the state will definitely want welfare of the functioning of the institution. It is not that he is here to oppose only. Maybe a private one governed by rule in place.
Not that way.
Governed by rule in place by the state government.
So what?
I'll show you.
No locus stand, no locus.
Locus stand hai.
If you will come as a public spirited people, then he
It's
is
not a topic in the litigation. I'll also answer that.
Shall I? If all of you permit me,
Yes, no,
Kindly be seated.
Ma'am. If there is no seat to sit, I'm standing, ma'am.
Kindly be seated.
There are no seat to sit now. There is
Now, sit. That's all. Petitioner has the following prayer column. Petitioner has the following prayer column. Next paragraph. Learned senior advocate appearing for the petitioner submits that the subject application supported by affidavit seeks leave of this court to amend the petition, the new managing committee, governing council, governing board having been normatively constituted afresh, and therefore leave be granted. First off. Next paragraph. Learned panel counsel appearing for the college on behalf of Mr. Jana, I am learned AGA appearing for the official respondent. Learned panel counsel appearing for the college resist not only the application for amendment but also the main petition, contending that a fresh cause of action having accrued, a new proceeding can be brought about, and that remainder of prayers that are arguably have become infructuous can also be loaded to the prayer column of the new petition. First of all, I am able with this proposition because all contentions that have been taken up in this petition can be loaded to the pleadings of the pleadings to be structured on the new cause of action. First of all, next paragraph. In the above circumstances, this petition is disposed of as having become infructuous, reserving liberty to the petitioner to approach the court on the basis of new cause of action, along with whatever remainder of the grievances that were made out in that have been made out in this petition. First of all, in that connection, all contentions of the parties are kept open. Ordered accordingly, and petition is disposed of. Objection.
Item 47.
Lord, in item 47, my lord, this matter has been listed for orders at my instance because there is an interim order by this Honorable Court staying the disengagement order dated 6/5/2025 under Annexure 12. Despite the stay order passed by this Honorable Court, the petitioner is not being permitted to join. Your Lordship may kindly take up IA number.
Is it true?
Mr. No, ma'am.
Are you ready to take him back?
No, fact remains. But by the date interim order was passed and communicated the same, by that time they have already been disengaged. So take for out, that purpose,
take out Chamundi Muppets. Take out Chamundi Muppets. Chamundi Muppets.
91.
Can anybody take out Google out that judgment?
91 Supreme.
Correct.
1342.
Yes. I believe, I vaguely remember, where stay order has been granted. Once a stay is granted, it is as good as status quo ante. But they have said like that. Apex Court has said like that.
But 10 days before that was passed.
What is fun in having the stay? If you say already they have been disengaged,
Oh, what is that great heavens will fall down if they are taken back? They are not made deputy commissioners.
No.
They are only teachers. Take them. And in their place, have you made any other appointment?
No. No.
Then what is it? Now you take, ask your officials, take back these people to the engagement. That is the minimum thing the respect should be. Or have you filed any application seeking that you have passed the stay order? By that time, we have already disengaged them. Therefore, we cannot implement the stay order. Recall that stay order.
For that recalling, it was filed the order of status quo in respect of stay in place of, it may be status quo because by then
you
they
take
have
them back. You take them back. Learned counsel for the petitioners. Only one petitioner, how many?
Well,
One petitioner.
there are 6 petitioners.
Petitioners.
6 petitions.
Points out that a coordinate bench of this court-wide order dated.
Order dated, this is order dated, my lord, 35/2025.
30 May 2025 had issued stay of impugned order of disengagement.
Dated 6/5/2025.
Made on 6/5/2025. Semicolon. However, despite this interim order, the petitioners have not been engaged as before, and therefore definitive action should be taken against the erring officials. First, next paragraph. Learned AGA Mr. Mohanty, appearing for the official respondents, opposes the contention, opposes the application, contending that by the time the interim order was granted, already the petitioners were disengaged, and therefore the interim order was not renewed to their benefit. First up. Next paragraph. Having heard the learned counsel for the parties and having perused the petition papers along with the subject application, this court is inclined to direct the official respondents to re-engage the petitioners in services in as much as there was an interim order granted by a coordinate bench of this court, semicolon. It is specifically admitted at the bar that in the place of these petitioners, no new hands have been engaged. Semicolon. After all, petitioners are not holding the high positions. Semicolon. They are only
junior teachers.
Semicolon. No institution should remain without teaching staff. Semicolon. Right to education being a fundamental right, a kind of fundamental right in the light of Rajkumar versus Gulbarga University, so and so. First off, no prejudice would be caused to anyone if petitioners are re-engaged in service as before. First off. Next part. In the above circumstances, a positive direction issues to whom?
Well, to the district education officer.
To the district education officer.
That is opposite party number 4.
OP number 4.
Yes.
To re-engage or cause to be re-engaged. Re-engage the petitioners or cause to be re-engaged. Within how many days? Within 1 week.
10 days.
Within 10 days. Within 10 days. And call this matter first. Call this matter on 19 August 2025 for reporting compliance. First off, non-compliance will be viewed very seriously, and some stringent orders, including costs and making of adverse entry in the service records, may be issued.
To that effect, I have filed the IA. That may be disposed of.
IA,
IA, it is in the board,
IA for?
I am for recalling of that order because the order dated 35 and the order was passed in 6/5.
Yes. One more sentence, above that you have to write. The application seeking recall of the interim order granted by the coordinate bench is liable to be rejected since petitioners have made out a prima facie case for continuation of the interim order with appropriate modification. That enough.
But so far as connected cases are concerned, the interim
and accordingly it is, since a prima facie case is made out for continuation of the interim order granted by the coordinate bench with appropriate modification.
But so far as connected cases are concerned, the interim order was passed on different dates. That is 23/5/2000.
Don't put the date of the interim orders. Make a similar order.
Yes.
But the first case is on concern that is 35 and order is 6/5. So dates there were, but in other cases,
Interim orders were
the
passed
interim
on
order is different and
Different interim order.
different dates. Interim order is same. Disengagement order has been stayed.
Dates you have to look at other petition.
But I am giving a list.
Different dates.
I am giving a list.
Yes.
Interim order to continue
Interim order to continue.
in all the cases.
In all these cases. As modified. As appropriately modified.
Yes.
Also.
Item 48.
Please, Your Lordship.
Yes, sir.
That my Lord, respectfully submitted that the Honorable Court had been pleased to direct the person to serve a copy of the writ petition on the opposite party and file requisite within a period of 3 days. That the petition has not been filed today, and I pray, Your Lordship, tomorrow.
1 week granted for doing the need.
My Lord, miscase is there, my Lord.
Mistakes.
Miscase is there.
What are those?
My Lord, I that my Lord, that the opposite party has not releasing the withheld amount of 1,42,244 from the petitioner's gratuity, which has been deducted pursuant to the gratuity payment order dated 26/7/2024, annexure 18, my Lord.
What is that mistake you are finding out?
My Lord, the MECP scale is there, my Lord. Petitioner case is that, my Lord.
No, that mistake you rectify.
My Lord. But I meant rectified. He had to rectify it, my Lord.
It is a mistake from their part.
My Lord, that part.
Let us see now. You take steps now.
No, there not appropriate order may be passed in this case, my Lord. I pray, Lord.
Miscellaneous, what you without notice to them.
No, notice maybe go and
notice go afterwards you consider. The application seeking the application in IA.
IA, my Lord.
IA number 1/4.2.
My Lord.
1/4.2 of 2025 will be considered service of.
Grateful, my Lord.
49.
29 were for the Navodaya Vidyalaya Mahela.
Yes, sir.
Copy number 1 and 2, and it has already has given admission on the law since 2023. It is want to infectious.
Yes.
My Lord.
And has become infectious.
Yes, my Lord. Because already she has given admission on 11/10/2023. Now he is standard 7, class 7.
Earlier he was a class 5.
Class 6, my Lord.
Class 6.
Class 5, there is an examination conducted by the Navodaya Vidyalaya Samiti. The students, those have...
Petition have the following prayer column. First, next paragraph. Learned DSG, I know?
DSG, yes, ma'am. Yes.
Yeah. So it's that petitioner having been already granted admission and having been promoted to next higher standard of studies, has become infectious and accordingly be disposed of. First of all, there is none from the petitioner's side to controvert this subject.
That is the withdrawal memo, I think, sir.
Withdrawal memo is fine.
Yes, that is ready is there.
I know, kindly see that I did not. I made to learn reading of your carnist. Very different carnist.
The head note is withdrawal of the
Okay, you are right.
That is memo.
My friend. Petitioner has moved memo dated 23/7/2025 seeking leave of the court to withdraw the petition as having become infructuous. First off. Next paragraph. Learned DST agrees with the proposal in the memo. First off. Next paragraph. In view of the above, petition is disproved of as having become infructuous. Okay.
If the, may I place this on before?
Fifth.
The present petitioners are the legal heirs of this petition. Petitioner 1A and 1B, the son and daughter.
May I submit, my lord?
Yes.
I am appearing for the BDA, my lord. On the last occasion, my lord has directed to obtain an instruction regarding the representation file they have filed. They have filed one representation in the year 2023.
My lord, let me submit my case. Let me submit.
I have to file counter affidavit for that reason. I have to file in that we have not filed the counter affidavit because of that reason. We have already
13 matter.
No, for that reason we have not filed. We have already prepared, my lord. By tomorrow we will file. By tomorrow.
No, for what reason you have? For what?
Last order may be seen. Last order may be.
My lord, the present petitioner 1A and 1B are the legal heirs.
7 weeks. No, after 12 years, I don't permit filing of objections. 12 years. What is fun in having objections?
No, my lord, the matter was not.
You pay 12,000 rupees, then we will permit it. Not otherwise.
Tomorrow, my lord, it is already prepared, my lord.
You may prepare it, keep it in your pocket.
No, my lord.
But court wants it. If you want to file,
today I was going to file, but the problem
all that
is that
story,
my lord, due to illness, my lord, I could not file.
12 years, why it was not filed?
My lord, the matter was no.
You pay 12,000 rupees, I will permit you to file objections. Otherwise, you have to argue without objections. 12 years, you can't, people will laugh at us. We cannot get down from the car. They will stare at us, saying that what kind of judges are appointed to this court. 12 years are lapsed. If we just tell you to give, please understand.
My lord,
argue on law. You are a lawyer.
No, my lord, I'm getting the point, my lord, but
to bar association, you pay 12,000. Then we will permit you. Otherwise, not.
My lord, little bit low, my lord.
Not
little bit.
11,000 rupees. Send little bit.
My lord, for affidavits, my lord, the thing is that
brother, in this time, your friends, many friends are sitting behind.
I know that, but
they will laugh
12,000
not only at you, but me also. Therefore, pay 11,000 rupees to advocate. Any welfare fund is there?
Yes, my
you pay.
High Court Bar Association.
May it be 6,000 or 5,000, my lord. It is high.
Learned your panel counsel.
My lord, on behalf. Yes, my lord.
For who is the respondent?
Respondent, my lord.
Development Authority. What development it does? Development. Petition is of the year 2013. It was filed on 21 May 2013. First time. Now we are in the August of 2025. First time. Till date, no counter is filed, nor any explanation is plausible explanation is offered for filing one. First time. Learned panel counsel appearing for the answering respondents seeks leave of the court to file his counter now. First time. Learned counsel next paragraph. One sentence. Learned counsel appearing for the petitioner submits that counter cannot be filed at this length of time, the normative period prescribed for that having expired. First, I agree. First, next one. Having said as above, denial of leave to file counter, although belatedly, will not be doing justice to the cause brought before the courts. First of all. Therefore, leave having been accorded, the counter can be filed within 1 week, subject to the condition that the answer with respondents. They will be counter in time. Don't worry.
234. 234, madam.
234. All their Bhubaneswar Development Authority.
Yes,
the respondent subject to respondent Bhubaneswar Development Authority paying rupees 10,000 to Advocates Welfare Association.
Fund.
Welfare fund. To advocates, welfare fund.
High Court.
Today I can file.
High Court
Today I will file little bit low. Little bit like that.
Orissa High Court.
Orissa High Court.
Advocates Welfare Fund.
Welfare fund. Within 2 weeks. Within 10 days. Then to file counter within 2 weeks. First, call this matter arms when 2 weeks will be over. 22nd we call this matter.
My lord, not available in Odisha from 20 to 25th of August.
You are running away.
I'll be at Andhra Pradesh. I'll be at Andhra Pradesh, my lord. So
You are going to Andhra Pradesh.
yes, ma'am.
Which day?
After 25th, any date.
We'll call this matter on 25th, 26th?
My lord.
26th.
My lord, no. Sorry, my lord. 26th, I'll be in the train.
It will be 26 will be free. Alright, we'll have this matter in first week of September. First week of
Yes, my lord. My lord, interim order is there. Interim order
to continue till next. Interim order is there.
Yes, my lord.
Then call this matter in the third week of September. Interim order to continue. Next.
From 52.
So, item 51,
That has been adjourned.
not informal was,
They have taken time without informing
and
you.
for the opposite party, they have not informed.
Then it's a complaint against the bar members. I cannot entertain. They should at least inform whenever time is taken. One phone call. I have taken time. I am informing you. Even that courtesy is not shown to the colleague at the bar. This is bad. Now, whether order is already written, I will send them.
Item 52. Item 52. My lord, filing the counter now, my lord. Filing the counter.
Which year matter?
2022, madam.
How many years have lapsed now?
2 years, my lord. Yes.
What is the normative period for filing of counter in under river rules? Anybody? Anyone can tell the rule? Which rule prescribes what period for filing of counter?
According to High Court rules, it's 30 days. But
2 weeks, court can
Which rule? Which rule? It cannot be a matter of debate.
We normally follow Odisha High Court rules.
Which is that rule?
That book is not with me.
I will give you book now. Give that Orissa rules. Let him look into it answer. Shall I call it tomorrow? You will call it tomorrow. Call it. Somebody has to tell me now.
Your lordship may extend my interim protection.
Interim order to continue till tomorrow.
I'm good.
Or till next week, we'll do that. If you call next week, interim order to continue till next date of hearing.
Item 53.
May it be the lordship.
Yes.
But the order under Annexum 9. That was that was passed by the Raulkela Development Authority. That is under challenge.
And there is a 9 in challenge.
Milord.
What is that order?
Milord, here in this case, fact means that the Raulkela Development Authority, in fact, allowed they leased the MIG 21, the house, in favor of one Dayanandi Tripathi. Dayanandi Tripathi was expired and subsequently his wife also expired.
Then widow also expired.
Expired. Both of them expired, leaving behind their sons and daughters. Out of one son and 2 daughters, give a power of attorney to the rest 3 daughters. Those who have been added in the opposite part 2 to 4 in the present litigation.
Power of attorney.
To sell out that property to contest litigation, a power of attorney executed. On the basis of that power of attorney, the OP2, the daughter of that late lessee, that Dayanandi Tripathi, he has taken 14 lakhs from me. I'm an old lady, I want to purchase that house, MIG2 house, for my legal necessity. And 14 lakhs he has taken me. And
I want to purchase house for legal necessity. I can sell it for legal necessity.
To reside.
to reject it.
Hmm.
Then he did not return back that amount. I intimated to the in view of there is a clause. That is your lordship kindly clause. The lease deed.
You remitted that money to whom?
To OP number 2, lordship.
OP number 2.
Million. There is a clause under the 10 that land cannot be bequeathed or reach out to anybody's without in absence of any written permission of the Outlaw Development Authority. That is page 23, your lordship.
Now, what is your prayer here?
Now my prayer that I made a representation to the Outlaw Development Authority that not to allow sell out that property in favor of anybody because she has taken money from me. Because there is a
Asking them to grant a decree to you, money decree.
that is the
You are going to the court, etc. You can't say, she owes money to me. Therefore, you don't give permission to sell the
on the basis of clause of that lease deed laws. The clause
in that?
Yes. Lordship page 23.
23. Go to 23, brother.
Annexure 1, page 23. There is a clause.
Which clause?
Clause 10, your lordship.
That the lessee shall not buy.
That the lessee shall not by any means
Between mortgage, change, transfer, or rent of letter, part of possession of the remains land. For any person thereof to any person without obtaining first written permission of the lessor.
The lessor is the
Development Authority, but shall not be required in case of mortgage. Who are you?
I am an intending purchaser of that.
You file a suit for specific purpose.
I know. That is there.
Right.
Now my friend has the 2 to 4 they have appeared by and they have filed a counter.
Correct.
They are willing to refund that amount to me.
They are willing.
Yes.
I am for
With
I am
Are you willing to pay?
Yes, I am appearing to
My submission.
One second. If willing to pay.
My submission is, your lordship, if the matter is remitted back to the district mediation center, Raulkela, and both parties will take back their money there, the matter can be disposed.
No, we will do it here only.
Exactly.
Why there again?
Milord, that they have taken money from me, that 14
They are
lakhs.
saying we are going to pay back.
Yes, Milord. That with the
We will not
interest.
create your paying.
Your lordship, that
During
with the
this, my lord, they have paid 14 lakhs. Out of 14 lakhs, they have returned back 4 lakhs. 10 lakhs, 10 lakhs with me. I am ready to pay within 10 days the 10 lakhs.
with the interest, your lordship. Because they are old man, old lady.
Old age has anything to do with the interest.
That I am not saying.
I
They have
don't know.
taken,
I am asking you.
They have
What
taken
state
money.
maybe there may be different laws.
since 2019, that money is with.
And that
Interest
agreement,
you pay that, some interest, reasonably. Which is the reasonable interest, AGA?
My lord,
Generally,
7%, 7%.
7%. Not my judgment. I have asked him and he says 7%.
yes.
Pay that 7%. Over?
Yes.
Petitioner is.
I am for opinion number 1.
I am for
opinion number 5, my lord.
All right, you can't have any grievance between them. It's a private.
I am the development authority, opinion number
All right. Petitioner, kindly be seated. Petitioner is before this court with the following prayer column. First of all, the list is sought to be put to an end by the offer of OP number 2. Correct?
Yes.
OP number 2, who undertakes to pay back rupees 10 lakh to the petitioner with the interest at the rate of 7% per annum. Per annum. Within a period of 2 weeks. Within a period of 2 weeks. Failing which, the rate of interest would be 1% per mensem for an initial period of 3 months and 2% per mensem for the period next following. First one. Next paragraph. Learned counsel for the petitioner is fully agreeable with the above proposal
And he adds that it should be treated as an undertaking given to the court, so that if there is non-adherence, the same would amount to contempt of this court. First one. I agree. First one. Next one. With the above observations and undertaking as recorded above, this petition is disposed of. First one. It is open to the petitioner to move an appropriate application in the event the undertaking is not adhered to.
Here also the report annex of 4. That is the recommendation that was made to the RTA authority.
Anyway, he is saying your list is over now. Petition is destroyed. Okay. You wanted your goats back. And he is saying, I am giving back. With that, it should be over. You need not go for the entire the evolutionary history of the goats. How goat evolved like this. We need not read Darwin's On the Origin of Species, the famous book which he wrote when he was in HMS Beagle. Yes,
Item 54.
Yes, sir. Yes, sir.
The petitioner is retired Lady PM of Barampur University.
Yes.
Of Barampur University. Lady PM of Barampur University.
Lady PM.
Lady PM. She has retired since 31/3/2022.
31/3/22.
22. She has asked for the pension.
Pension is not given. How many years she has put in?
There is one. She has asked for the pension, whereas she is being offered CPF. But this is guided by Rule 289 of the Statute 289 of the University Act.
Statute 289. What did it say?
289(3) says that, my lord.
Where is that copy?
I have already quoted the provision there in the petition.
You quoted it.
I have put it.
Every employee retiring on or after first day of April 85 be entitled either to the benefit of the pension scheme as applicable to the state government employees as amended from time to time, or to the benefit of the contributory provident fund of the university provided in this chapter as he may opt.
Provided for that for the purpose of contributory provident employees shall be defined in chapter 7 of the SPART. Thereafter 289(1), the existing employees who have not already exercised their option under the statute shall exercise their option in writing either for the pension scheme or the contributory provident fund scheme under statute 288 within a period of 6 months from the date the statute come into force. The employee recruited thereafter to the service of the university shall exercise their option either for pension or contributory provident fund scheme within of their appointment.
Provided that
the employees who have crossed the age of 58 years but have not attained the age of 60 years shall also have the right to exercise their option as aforesaid within the period of 6 months from the date these statutes come into force.
Which was your option?
I have not exercised any option during my service career. Therefore, I invoke 289(3), my lord. 289(3). I take your lordship to that. If any employee fails to exercise the option required under these statutes,
you will get a pension.
I go for pension.
What is?
Therefore, I have applied to them, but they in their counter say that I have already opted for the CPF.
Had she opted for CPF?
They say so, my lord. My client stoutly denied it.
Let us see that.
They have said in their counter.
Where is the proof?
Environmentally, in complete document, I did administer J/2 under my counter. Complete document submitted. Section. Proceeding the committee meeting constituted to the scrutinized examiner regarding their eligibility of the application submitted by the in-service and retired employees with regard to change of option from CPF to GPF.
Now, where is her application? This is the proceeding.
No.
This proceeding is structured on which application? Where has she put the signature?
Option for my counter page 12. A by 2. A by 2. A by 2.
And is that F bar 2?
A by 2.
A by 2. Go to A by 2 page number
12.
Internal page 12 counter.
What is this?
There is a copy of the dark book that they have received it. They say.
Dog book.
Dark book.
What is that dog book? Cat.
Dark, D-A-K.
Dark book.
Dark book. Post.
Okay.
They said to have received it. And thereafter the note sheet says that they have accepted 13. But let them either show the service book of mine, where it has to have been entered,
Enter. Employee has opted for
or my signature means.
scheme or opted for pension. Where do you say that generally? In the service register.
In the service register, they have to say.
Generally, you will enter everything relating to an employee in the service register. Show it from the service register, one option. Show her application where she has put in signature.
Exactly.
Second option.
For that option,
Assume that employee has opted for this, that, etc. Otherwise, the class 3 will commit suicide. It will commit legal suicide. It cannot happen. Nothing.
That's in paragraph 4 of my counsel.
Paragraph of contents. All that is not available. That will not help you. The point is, she is saying, I have not given option. She cannot be asked to prove the negative. Section 101 of the Evidence Act. It's a general principle. There is a general principle. 101 says, give that Evidence Act. The person who asserts should prove that assertion is true. Take Evidence Act. That applies general. Supreme Court said in 2-3 judgments that it incorporates a general rule because negative cannot be proved. She is saying, I have not given. You are saying she has. Show that.
One minute. Take instruction.
Again, you have filed other document. Where is the instruction? The question is, you have to show her application, her letter with her signature. May not be. No signature necessary with her letter. Will allow this petition. You have to give pension scheme.
Already he received the CPF scheme.
She has received.
I know.
When did she receive?
Annexure G.
She received that benefit.
Why not?
That is right. Is it you, brother?
That I have to take instruction, but I have sought for one IA wherein I have asked for the document.
Don't worry about document. Have you accepted that contributory scheme?
No, I have never.
But he said
I have never opted for it. I have never opted. It will be forced upon me.
What forced upon you? When did you make when you received that?
Annexure A by J last page.
How much money has been given to her? When?
Annexure G by 2, 6,32,625.
6
Like for each document. Annexure G by 2, page 19.
Annexure G bar 2.
G by 2, page 19, each counter.
6,32,625 is paid to you in 2023.
No.
You filed this writ petition when?
I filed the petition as the cause of action that was on September 2022.
How?
My lord, I have given a letter to them. That is Annexure 4, my lord. Annexure 4, page 19 of my petition.
What is that letter?
My lord, I am doing. My lord, it is.
But subsequently, you have received that money. You have sent it back saying that no, I don't accept this money. This I don't want. You give pension.
My lord, I have written it.
Where is that?
Annexure 4 is there.
Annexure 4 is before that.
Before that, my lord.
Subsequently, where have you stated?
Subsequently, I have not. Subsequently, I have filed the case.
Well, after what period? You received the money state. Annexure go to that.
On 2023.
Which date?
They also have reviewed the RTA application of mine.
That's all right. When did you receive that
I have
money?
filed the application
You received that money when it was credited to her account?
Until 11 2023.
11/11/23.
2011-2023.
Pardon?
20th November 2023.
20th November 2011-2023. You have paid that money. When you made the application to them saying that what you have said is not true, I don't take your money, you take it back, give me pension.
I have applied on 2/9/2022. Thereafter,
that makes no sense.
My lord, they have also asked on 24/8/2022 that anybody opting for this CPF scheme, anybody opting for this pension scheme, may file their option. Therefore, I have opted for it. I have applied for it.
Where is that option?
That option is
you. They opted for pension.
Yes, Annexure 5 is the Annexure 5 may be seen at page 20. That is their notification.
This is 24/8/2022.
22. It is for the information of all concerned that the Vice Chancellor need to consider
submit their application for option.
Constitute
How
committee.
you do?
So they sought for the option. I have given the option at Annexure 4. And that option has been not considered is Annexure 6.
1 second.
Supply of information.
It cannot be Annexure 4 because Annexure 4 is anterior to that notification. Thereafter. Annexure 4 is earlier to 24/8/2020.
Annexure 4 is dated 2/9/2022. 2/9/2022. And this notice is 24/8/2022. The receipt section has also received it on 2/9/22 as can be found out from Annexure 4 bottom part. Receipt section.
Dispute the notice you cannot dispute because it is your university notice only. Annexure
6 may be seen, my lord.
24/11/23. Do you dispute this annexure in your objection statement in counter?
May I advert your lordship said to pay Annexure 6, my lord.
I'm seeing that 24/11/23. Kindly read Annexure A6.
Annexure A6.
From change of option from CPF to GPF. That is pension. That means you are already opted for CPF.
No, my lord. I have never.
Otherwise, how will you make this up?
Let them show my signature anywhere.
No, you read application. You read your application.
Which application, my lord?
Your 24/11/23.
24/11/23, my lord. With reference to your letter on subject cited above, it is to state that the finance wing has informed that Srimati Panda remained under the CPF scheme since the financial year 97-98. I want that only, my lord. That is my contention. Let them show where I have opted. They simply say, the note sheet says.
No, you only have said.
This is not my application. I have not said.
24/11/23 is whose?
My 24/11/23 is the letter of the public information officer. That my letter, you was not considered. My option was not considered.
Where is your you don't have any option at all? Is your case?
My lord, I have never.
Therefore, you fall into
earlier to this
class 3.
2/9/22. I had not opted any day. My lord, I am a last grade ready peon appointment. I do not know about all those things. After retirement, I opted for the pension scheme. The pension scheme was not considered as per the Annexure 6.
It is verified by the Diary Register of Administration NT section that existing employee Srimati Ponda, like petitioner, has submitted her option from duly entered by the diary number 2792 dated 6/9/1995, that is well within the 6-month time period. As per the statute 289(2) of the option as provided above shall be exercisable once only. Hence, the committee did not recommend her application for change of option from the GK.
They do not show my signature anywhere.
But this happened long ago. You have accepted money also.
My lord, what can I do? I
should have said that.
am a retired peon. I have sought for the changing over to that pension scheme. They did not pay pension. They did not act upon it. Naturally, whatever came my way.
Pension will be how much?
I don't have any idea. Must be better than this amount.
And therefore you have come to court is another.
No, because
But
it will be available for a longer period and small amount, not like this heavy amount. One-time payment, heavy amount. So each month payment, some amount I will be getting on till I leave.
no, but you have accepted that money without protest.
My lord, after my application, what sort of protest could I have put down?
You should have sent a letter. See, all your letters and other things you have already told them. You should have said,
I have already told
you have created this money. I do not want that. You give me pension. I have not opted for anyone. Therefore, my case fits into class 3 of the
a lady who has nobody to rely upon, her husband is dead. This is the education appointment, my lord. After retirement, 2 years after, if they, whatever comes, she has to accept it. If the pension is not available and nothing is there, no service, no money.
You retired on which date? 31/3/22.
22.
And they sent the money to you on?
In the 23, November 23, as they say, my lord, that I have not verified because I have filed this IA to seek that letter where I have said.
Why more than 1 year, 8 months in settling the pension?
My lord, kindly send the para 10 of the counter, paragraph 10, page 7.
Go to para 10.
It is
Page 7.
somebody my counter.
Page 7 of the counter. Paragraph 10 is this. Right to the following the conditional for like 78,000 on 32 copy of sanction for the dates. When the final withdrawal of CPF accumulation, when she withdrew that on 33/22, I'm asking you now. It's your pleading.
My lord, 4,38,747. 33, 2022.
Plus 6,32,625 subsequently.
23.
In 2023. Then come to gratuity DCRG amounting to rupees 6,15,060 has been released. Why letter dated is annexed so 2022 itself. Brother, you have taken, you are richer than Harshad Mehta. 4,38,747, 6,32,625, 6,15,060. 3 sums are given to you. And all you have accepted. All of a sudden you come to the court saying that no, I want pension, not this money.
My earlier claim stayed with them. The pension I have demanded.
Totally, how much
my
money
pension
is paid to her? All these 3 separate amounts. You are not answering, you are assisting properly. You are representing the university. Whether university is producing only people like you.
Seniority.
Brother, no, you are turning around and you are blowing hot and cold. That is not permissible.
No, my lord. My lord, imagine the plight of the lady.
Flight. She can take a flight to foreign country with this money and reside there. It is not a case of
He
plight.
doesn't know anything else than Udia.
You all taken, all people will say like,
No.
having taken the money. Urge you to engage a very efficient lawyer like you, approach this court, everything she knows. Because of this money.
My lord,
There is none. Perfect. Right.
may I brief?
You have argued that. How long I should hear this matter? It's a short matter.
Nothing to be heard, my lord. Let them produce my letter.
Nothing. Please be seated. But I have heard. But
May I pray, my
the
lord?
short difference of
I have submitted a IA for the production of document.
who will reject that objection. The grievance of the petitioner can be understood from the text of the petition.
May I take your lordship to the decisions of this honorable court?
All this give them. Give those copies. What are the propositions? No, that way I will not take. You have to give in a bunch. You should say what is the decision, what are the facts, what is the proposition. This is not a tea shop. You cannot dump some decisions and go away. Who will read them? Apex court say, unless decisions are given in an organized, structured way, court will not entertain them.
I am placing the
What are the propositions?
proposition. He only stated this 1 and 3. Both together, my lord.
No, will not take.
Statute 289, 1 and 3.
No, will not take.
And for the people who have opted, my lord, who have earlier opted but have resigned subsequently.
The grievance of the petitioner
The same situation persists here. If at all they are able to prove.
by perusing the
My lord, 1 minute.
plain prayer scripted in the petition.
1 minute just.
Learned counsel for the petitioner vehemently argues that his client, who is not much educated and who was in the lowest rung of the service as a peon, had not opted for which scheme it is?
The CPF scheme.
CPF.
Just 1 minute. my lord.
Therefore, she ought to have been granted regular pension, her case squarely falling in clause 3 of
Statute 289.
statute
289.
9 of
Question under statute 289, 1 and 3 of the
learned after service of notice, the opposite parties having entered appearance through their panel counsel have filed the counter resisting the petition. First off, have learned counsel for the learned panel counsel submits that the petitioner has been had opted for CPF or GPF? CPF, and accordingly, her terminal benefits have been settled. First off, next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, this court declines indulgence in the matter, broadly agreeing with the submission of learned panel counsel appearing for the university, in as much as the petitioner retired from service on 31/3/2022, and she has received the following sums of money. Where is that page, brother? 6 lakh, etc. Which is that page?
It's 7 of the counter.
Huh?
It's 7 of the counter.
To page 7, yes. As reflected in para 10 of the counter. First up. Next paragraph. The mission of learned counsel for the petitioner that whether an employee has really opted or not, the burden lies on the onus lies on the employer, and in the absence of discharging the same, the employee should be treated under clause 3 of rule 289 is broadly true. First term. However, there is a discharge of such an onus in as much as the payment to the university under the GPSR.
CPF.
No, payment is made under which scheme?
CPF.
Under CPF scheme is not disputed by, not only not disputed by the petitioner, but she has appropriated a huge sum of money, which is to completely add that money. So and so, so.
My lord, appropriated would be a negative word.
Right. You have taken that money.
I might have
They say accepted that money without raising even a little finger. Little finger. First term. Therefore, contention to the contrary cannot be countenanced. First term. The reliance, give that any judgment you wanted to rely upon, give that judgment. The reliance of learned petitioner's counsel on a decision in Dr. Dibakar Panigrahi versus Behrampur University, 2021, 1 ILR, Katak 213 would not come to his aid much, in as much as that was not a case where the employee had accepted the amount already paid under the said scheme, unlike the case at hand. It hardly needs to be stated that Lord Halsbury in Quinn versus Lytham 1901, HL so and so has observed that a case is an authority for the proposition laid down in a given fact matrix and not for all that, that would logically follow from what has been so laid down. First, in view of the above, petition being devoid of merit is liable to be dismissed, and accordingly it is, courts having been made is. Having received money, you cannot turn around. Yes. What sentence your petitioner?
I could have returned the money, could have taken back.
Item 55.
Next.
Well, please, Lordship.
Yes, Doctor.
Lordship, counter has not been filed, Lordship.
Counter is not filed.
Yes,
Take advantage of non-filing of counter.
Filing any debt, Lordship.
Not filing well, first round failed now. Going to second ground. Call this matter in the third week of September 2025 at the request of the debt counsel on the health ground of the arguing counsel appearing for the petitioner.
Item 57.
Obliged.
56.
Item number 56, my lord, and 57 are two matters.
56, 57 connected matters.
By the same petitioner, what are two different prayers? Of course, there is some interconnection between the two, but the first one is the 12549 2024, where the prayer is challenging the initiation of departmental proceeding against a person after his retirement, specifically on the ground that there is no provision available in the corresponding statute authorizing the authority to initiate a proceeding against a retired employee.
Post-retirement inquiry.
Post-retirement departmental proceeding
in respect of pre-retirement misconduct.
Pre-retirement misconduct, my lord, I am not going into the merit of whether misconduct has been committed or not. That is lordship. The legal issue here is whether in
the absence of enabling provision.
Yes. Whether
post-retirement inquiry is permissible.
Yes. Yes. That is the sole point. And for that purpose, the crux of the issue is what is the status of the employee and under which rule he is governed. So here is a case where a
what was he?
Yes. He is a professor
working in a state agriculture university, that is Odisha State.
1 second. Professor in Agriculture University.
Professor in Agriculture University. OUAT. For short, it is OUAT.
When he joined service and when he retired.
Well, he joined service way back in 1989, and your lordship may kindly come to the retirement. Retirement date is 3/2022.
99, 2009, 20 years plus 5 years, 4 years. Retired.
Yes.
Then inquiry started when?
Inquiry, well, the impugned inquiry, the charge memo was drawn up on 2/5/2024.
Drawn up or served on you?
Yes, that is the memorandum which was served on me on 3/5, the following day.
3/5/22.
24.
24.
2 years after my retirement.
1 second. What was the misconduct?
Well, the misconduct, your lordship, misconduct, they say that there is a violation of Copyright Act.
Violation of
Copyright Act, for which a proceeding is initiated, and that to the document itself shows I am not involved therein. It's a wrong they are committing. For that purpose, I am straight away taking your lordship.
What is that copyright?
Yes, their allegation is, when I was the professor of that particular department, a winter school was organized where different researchers, they provide their respective write-ups, research papers, which were compiled into a book. That was published way back in that was published way back in the 4 years prior to the retirement, and in the year 2020, with the lordship's permission, can I draw your lordship's attention? That book was inaugurated by the minister concerned of the department in presence of the VC and everybody. Your lordship may kindly see. This book.
That book was released.
Said book was released by the minister, honorable minister concerned, Minister of Agriculture. And my lord, I am simply I was working as the HOD then. And my lord, your lordship may kindly come to Annexure 4 on page 24.
Slowly. Okay. Be slow. What is violation of copyright?
My lord, they say, after publication of this book by the university, my lord, neither this book was registered under the Copyrights Act. That's a thing which is to be gone into on merit. We are not going on merit, sir, because we are on the initial issue whether such a proceeding can be done. Since your lordship is asking, I am just answering.
Let us see the charge memo.
Your lordship may kindly come to Annexure 3, running page 19.
3, page
yes.
19.
19. Charges your lordship will find page 20.
What to fancy?
Page 20. That is article of charges followed by the memorandum. Your lordship got it? Last paragraph. For the above condition, Dr. Naik is charged with the following charges: violation of copyright, so on, so on.
You published that?
No.
You have not published?
No, that was published by another organization, that is NIPA.
Once. NIPA.
New India Publishing Agency, NIPA, New Delhi.
Is it a private agency?
It's a private agency, and your lords may kindly come to page Annexure 4, running page 24. That is their own finding that I have got no role to play.
In that?
In that. That also your lords may kindly say, that is their own finding. Page 24.
Annexure A?
Annexure 4. Annexure 4, running page 24. Your lordship got it? Your lordship kindly mark at the top. This is a letter
written by the Dean, addressed to 3 persons. Myself, Dr. G.D. Nayak, retired professor and HOD ABG department. One Dr. K.K. Sardar, professor P&T, and another Dr. B.C. Das, ex-assistant professor veterinary extension. So these 3 persons were intimated by this particular letter. Well, subject with
any complaint is lodged against NIPA.
Well, your lordship, just my lord.
No, I am asking.
No. Your lordship, kindly see this subject. And this is after my retirement. I may kindly see. I retired on 30th of March 2022. This is a letter written on 13/6/2023. That means after a period of 1 year and 3 months from my retirement, I have been asked to, by this particular letter, to
whether copyright can be...
That is beyond the scope, because you lot...
I have not asked the question yet.
Sorry, but I'm extremely sorry.
Kindly wait. Whether copyright violation can be taken up when in respect of unregistered copy. Is there unregistered copyright? I do not know the law. I have not practiced on that.
Well, that is there. Well, that is...
I want to...
Well, exactly, my lord.
Now I have understood your case. Let us see. Now owner's shift now.
My lord, only one. Your lordship, before your lordship... My lord, I just...
Two things you are saying. Number one, post-retirement inquiry is not possible because the rules do not enable. Number two,
this itself is vague.
That they have admitted that I have nothing to do with that.
Yes. And more so, one line. Well, from the very same, I will be... Well, page 24, well, 3 persons were noticed, and your lordship may kindly mark the first paragraph itself. After thorough verification of the client...
I read that.
Well,
you have marked that the X mark you have put the left-hand side.
Well, the other 2 persons, they were signatories to
that book.
That agreement with NIPA. I am nobody.
You are nothing to do.
Nobody. So they themselves accept that my name has been...
Unauthorized.
Still valid, a proceeding has been initiated.
Let us.
Exactly.
What is?
Yes.
Yes. First, where is the authority to institute disciplinary proceeding? Which is the rule?
Your Lordship may kindly have a glance to the...
You take rest now. You have passionately argued.
Orissa University of Agriculture.
Why we have that top chairs? No chairs, no more chairs. Those who are having cases on yield place to the counsel on the feet. Yes. Which is that rule, brother?
Yes. But I have enclosed that. He's referring to that.
My lord, may kindly have...
It's the page,
Can you pass it on to...
I'll pass on the entire rule.
Yes.
He has referred to...
Only one rule, which authorizes. Post-retirement, inquiry can be held. Simple.
Yes. Lordship may kindly have a glance to this statute.
Just read so that others also will know.
Yes.
Read that.
Yes.
Forgive that. You just loudly read. Many youngsters will be here. They will be benefited. They will know the benefit.
Well, here, after retirement, the Lordship will look at page 16. He has enclosed that rule. Page 16.
Page 16. 1-6.
Page 16 of the writ petition.
Okay. Chapter Roman 6.
Yes.
CCA rules.
CCA rules.
Which rule?
That is Rule 46. Your Lordship.
Page numbers?
Rule 46. Page 16. 1-6 of the writ petition.
Correct.
Rule 12, 15, 16 of the Odisha Civil Service Classification, Control and Appeal Rules 1962 as amended from time to time, and the government clarifications issued thereunder in the matter of suspension and for imposing measure and
this. What are those rules?
Those rules are also available.
Give that.
Now here, my lord, the question is, these rules, both the rules as prescribed under this particular
Chapter 6, as well as the CCA rule. These rules, they basically deal with the existing employees. Now, post-retirement, the only provision is provided under the pension rules. That is Odisha Civil Service Pension Rules 1992.
But they are not adopted.
They have adopted, Your Lordship may kindly see.
Those rules also are adopted.
Those rules are adopted, but here the impugned annexure, I would fairly submit, my lord, the impugned annexure is bad in law to the extent it has been issued in pursuant to the provisions contemplated under Rule 15 of the OCA CCS Rule 1962 after retirement. Because after retirement, they could have proceeded against the petitioner
Under pension rule.
Under the pension rule, that is Rule 7 of the pension.
That has not been done.
That has not been done.
Then that relief has to be accorded to you.
I would fairly concede to that.
But I will say that you resisted the petition because of your fairness. I have to protect you. Otherwise, you may be deleted from the panel itself. Now, these are the days, na?
Yes.
Earlier, when great Sirwai, H.M. Sirwai was the Advocate General for State of Maharashtra for 17 years. Longest Advocate General, perhaps, after Jamshed Chipanga, I do not know. He gave an opinion to the government against the government. Then A.R. Antule was Chief Minister, asked Shirwai to come to his chamber and explain. He took it very seriously. He sent a letter. Blessed is the king who goes to the scholar. Cursed is the scholar who goes to the king. Please accept my resignation. That's how the standards were. Now, if they come to know that you have fairly made submission, they may remove you instead of appreciating you. Therefore, I will protect you.
And
only that much.
And that pension rule, if your lordship will kindly have a glance.
But how you can travel to pension rule at all?
Right now, I cannot.
You cannot.
I cannot. Because that order is bad itself.
But pension rules you have not adopted.
Yes. Yes, pension rule we have adopted.
Where are you adopting?
Your lordship may kindly see.
Not as part of this discipline and appeal.
This chapter.
Yes. As a part of saying that we have adopted pension, there is one.
For grant of pension, we have adopted this pension rule. But however.
Take out ILR 1997 Karnataka. Shankar Chowgale versus Managing Director. Can anybody retrieve that judgment? Thank you.
Right.
Shankar Chowgale versus Justice Thakur's judgment. Versus Managing Director or Karnataka Land Army Corporation. Anyone not these two. Identical issue is decided.
My lord, here, my lord.
But no favor.
Yes, my lord.
In his favor also, because there the rules were adopted.
My lord, here.
Disciplinary rules were adopted.
Yes, my lord. Here also, my lord, there are two judgments rendered by coordinate benches of this Honorable Court, which goes on to show that in absence of a provision to proceed against a retired employee,
is not permissible.
That is not permissible.
That's the.
If your lordship wants, my lord, I can.
No, this is well said. First year law student will be knowing
yes,
that.
Yes,
we need not duplicate the judgments unnecessarily quoting so many rulings, etc.
Yes, ma'am.
Take down. Petitioner, a retired professor, please be seated. He is invoking the writ jurisdiction of this court for interdicting the disciplinary inquiry sought to be taken against him on the alleged ground of some copyright violation. First off, learned counsel, next paragraph. Learned counsel for the petitioner vehemently submits that in the period between 1989 and 2022, his client was in service of the university, semicolon. He demitted office on 31/3/2022 on attaining the age of superannuation, semicolon. His service records are spotless, semicolon. To his dismay, comma, the university issued the charge memo dated 5/2024, alleging something like copyright violation as if it constituted a misconduct, semicolon. In the absence of statutory enablement, comma, no disciplinary action can be taken against the pensioner, stroke retiree. First one. He also adds that, in fact, the very university had addressed a letter to the effect that inclusion of petitioner's name in a particular publication itself was unauthorized. And therefore, there is absolutely no material to inculpate his client in the alleged copyright violation episode. First. Next paragraph. Learned panel counsel appearing for the university resists the petition, contending that there is a kind of misconduct which is worthy of inquiry, and therefore an inquiry has been constituted. Semicolon. It is open to the petitioner to take up all contentions in defense before the inquiry officer. Semicolon. The university, being the employer, is entitled to take disciplinary action even against retired employees, in as much as the university statutes have incorporated the state CCA rules as part of their own. First, he also quotes certain provisions of Orissa pension rules. Rule 7. You can sit down. We need not stand up. I feel offended because we are not superior. Most superior members are at the bar, and because of conspiracy of circumstances, we are sitting here. I tell you the truth. It is conspiracy of circumstances that I am here and you are there. More competent people, more competent lot is that side of the bar. Bar means this bar I'm using. It is that side. Let's sit down and answer. You see, not to be that this is not a primary school. How many times I should repeat this?
Statute 46.
Statute 46.
No, page 60. Pension rule, it is rule 7.
He also quotes rule 7 of Orissa
Civil Services
Civil Services
Pension
Rules
62. 1992. Sorry. 1990.
Next paragraph. Having heard the learned counsel for the parties and having perused the petition, you don't have dare to sit down.
And his next one.
My court is full of people now. What should I do?
And his next one.
Okay. Having heard the learned counsel for the parties and having turned the pages of the paper book, I am inclined to grant. This court is inclined to grant indulgence in the matter for the following reasons. First up. Next point. The first submission of learned counsel for the petitioner that his client, having spotlessly served, debited the office on retirement with effect from 31/3/22 is not in dispute. Second, the alleged incident did not happen during his employment is obvious from the record. Second, regardless of the contention whether the alleged act amounts to misconduct at all, no rule is brought to notice of court to authorize holding of disciplinary proceedings against a retired employee. First of all, therefore, the first contention as to competence to hold inquiry has to be answered in the negative and in favor of the petitioner. First of all. Next point. Learned counsel for the respondent university, although banked upon the provisions of Rule 7 of Orissa Pension Rules 1992, that would not come to rescue of his client in as much as the same has not been made a part of provisions relating to disciplinary proceedings, although generality of the same might have been incorporated as part of service rules. First term. Next point. Added. The proceedings sought to be taken against the petitioner are not relatable to these rules at all. First of all. Next point. Which is that letter where they said unauthorizedly included?
That is Annexure 4.
Sit down. Please sit down.
Sorry,
sir.
Sorry. Well, that your lordship will get at page 24.
Learned counsel for the petitioner is more than justified in banking upon the Dean's letter dated 13/6/2023, a copy whereof avails at Annexure A4, wherein the first paragraph reads as under. So, first paragraph you have to just look into this one, page 24 it is. I'll do one here. Yeah, you can get it. I'll put a flag here. Think flag for you. Yeah. And I'll put the yellow mark for which that becomes easy to you. Okay? Below that, two lines. The very letter itself is the contention of the petitioner that he had nothing to do with the publication of the book entitled inwards Impact of Climate Change on Livestock Health and Production, inwards complete, published by NIPA, correct?
Yes.
NIPA. NIPA. First time. It is not the case of respondents that this letter is erroneously scripted or unauthorizedly, its author being none other than Dean of the department concerned. First one. Next paragraph. In the above circumstances, this petition succeeds. A writ of certiorari issues, quashing
Annexure. Memorandum method under Annexure 3 dated 2/5/2024. Page 19.
Annexure 3 memorandum quashing the memorandum dated 2/3/2024 issued
2/5.
by
No, that is
the Vice Chancellor.
That is 2/5.
2/5.
Yes.
2/5/2024 issued by Vice Chancellor of the University at Annexure A3. The university is permanently interdicted from proceeding with the inquiry in question against the petitioner by issuance of a writ of prohibition. Courts reluctantly made easy.
The second one is relatable to that. And here my gratuity has been held out saying we are contemplating a proceeding against you. That is your lordship. It will consequently
order passed in the
why orders? Gratuity cannot be held.
Yes.
Contemplation of an inquiry.
Yes.
There is a judgment of
Yes. Your lordship, kindly see the impugned order.
Anyway, because of this, that also
here the question of contemplation was not there. Here the proceeding was initiated.
that has gone now.
Yes.
That makes still worse now.
Yes.
Because of this.
Yes, my lord. Yes.
So annexure 4 of the
Annexure 4 is to
be
passed.
Petitioner has scripted his prayer column as answer. First of all, his essential grievance is as to withholding of the gratuity amount on the ground of contemplated inquiry, which was the subject matter of companion WP number so and so, wherein very initiation of the inquiry has been struck off by this court, order made this day itself. First time. Next paragraph. In view of the above, this petition succeeds. Semicolon. Writ of mandamus issue, writ of certiorari issues, quashing
Annexure 4.
Annexure
4.
Dated
24/4/2024.
quashing what is this memorandum or what is that?
No, this is a letter issued to the
Quashing letter
issued by the registrar.
dated 24/4/2024 issued by the registrar of respondent university at Annexure A4.
Right.
A4 semicolon. As a corollary, a writ of mandamus issues to the university to pay to the petitioner the entire gratuity amount within a period of 4 weeks.
My return dues, everything has been withheld. Your lordship is direct as a consequence, everything has to be. All return benefit has to be.
as is admissible under law.
Gratuity and all retiral benefits. Retiral benefits.
Yes.
To the petitioner
Yes.
within a period of 6 weeks.
Oh, blessed.
6 weeks. With interest you have to pay.
Can I pay 2 months, my lord?
8 weeks with interest. With interest you have to take out that judgment, which is that Chandrasekhara Kambara versus take out that. Chandrasekhar Kambara versus Bangalore University. Or there is another judgment, Padmanabhan Nair versus Union of India.
Even under the pension rules,
There is a
even
interest
under
is
the
paid.
pension rules, it is 7% interest. So far as delayed payment of gratuity is concerned.
But pension?
From the
Pension is not a bounty. Yes,
the pension, your lordship can.
My brother has said our government AG has said 7%.
Yes.
We'll say that 7%. This interest at the rate of 7% per annum. From the date, record from the date, the same was payable.
20th April, 30th of
We have said
1st of May 2022 till today. 1st of May. I retired on 30th April.
And delay shall carry additional interest at the rate of 1% per mention for the first 3 months and 2% for the period next following.
But that delayed payment of interest on gratuity falls due 1 year after.
What a therefore, from the date it is payable.
Yes.
I did not specify that.
Not from the date it is payable as per the rules, but suppose he is entitled for gratuity from today. So unless there is a delay of 1 year,
no interest is paid.
No interest is paid. That is the provision under the rules. So what I am saying, my lord, it is from the due date, the date when he is entitled, he claims the gratuity is due to him. Once there is a delay of 1 year from that due date, then he will be entitled for the gratuity.
It is made clear. So far as gratuity is concerned, no interest shall be payable for the first year. For the first year, my first year.
Item 58.
Thank you for being so fair. Generally, fairness is not. It is not that people are not fair; they are fair. In fact, John Rawls.
Yes.
These are 2 books. One book is very, very famous book. It has fairness. And John Rawls was professor of Amartya Sen. Amartya Sen, in honor of John Rawls, wrote the idea of justice, for which he secured a Nobel Prize. Fairness is an aspect of justice, very essential aspect of justice.
58.
May I please, my lord?
Yes.
My lord, in this case, the petitioner is a student. He has scored 97 plus percentage.
97.
Plus percentage.
Even for 2 years, mine was not so much. Yeah.
My lord, his agony is
97 in which course it was?
10th class exam, board exam.
10th class.
Across all subjects.
It's a board exam.
My lord, his agony is 2 marks he deservingly should have been given. Have not been given. Prima facie, there are omissions in awarding him marks. Your Lordship, this was brought to the notice of the authorities through all the procedures established. They went through all the procedures, but the apparently ignored marks, apparently missed out marks were not awarded. That is the case, Your Lordship.
Why he is entitled to 2 marks?
My Lord, that's what. My Lord, the question number 36, which is at page number 28, I can be seen. There are 36 has 3 questions, 3 sub-questions. Question number 36.1 carries 1 mark. 36.2 carries 1 mark. 36.3 has 2 sub-questions and each carrying 1 mark. Each carrying 1 mark. So
it will be 4 marks.
4 marks. 36 carries 4 marks. 1 mark for 36.1. 36.2 1 mark. 36.3 has 2 sub-questions carrying 1 mark each.
Each mark. Each carrying 1 mark.
1 mark.
2 are correct answer.
All are correct answers.
All 4 are correct.
All 4 are correct.
So instead of granting you 4,
they have
granted you 2.
My lord, they themselves are marked it. I'm not claiming that I have given an answer correct and they have not.
Show that.
My lord, that's what the page number 60 and 61 would make it very clear. 60, my lord, the last line, 36, the page number 60.
60.
My lord. 36.1.
What? Not the 60.
Last one. 36.1.
36.1 or 35 point?
36.1.
36 point.
The last one.
36. You are right. Development which takes place without damaging the environment and development in the present.
It has been marked correct and 1 mark covered.
Compromise with so and so, so and so. They have given 1 mark for that.
It has been marked correct and 1 mark is given.
Correct.
Now let the next page.
They have given 1 mark.
36.2. They have marked it correct and given 1 mark.
International Earth Summit at Rio
de Janeiro, Brazil. It has been marked correct and 1 mark given.
In 1992. All accepted. 1 is granted. Assemble, so they have granted 1 also there.
Yes.
What is it, brother?
36.3.
4 marks are to be granted to
you. They have
given you 2.
3. They have given you 3. Counted 2. Forgot to give 1. That's what I'm saying. Just
1 mark to be granted to you. 2 marks to be granted.
My lord. 36.3, your lordship would see.
It is a case of retotaling. Not even revaluation.
No. Everything is clear, your lordship.
What do you say, brother?
No, my lords, as regards CBSE examination procedure, there is a foolproof process of 3-tier system introduced in 2017, where for the benefit of the student, they have introduced in the first leg verification of marks, where the marks he has to apply and the marks are verified in a retotaling or totaling process. And it's only found that on the margin or on the seat, calculation seat at the top, whether the calculations and additions are correct or not. And if he is aggrieved by that, then also he is given another chance in that 3-tier system I'm talking of, that he has to apply for the photocopies. And photocopies are granted. And even then, if he is aggrieved by that also, revaluation process is available for him.
Where is revaluation?
Revaluation in that particular 2017.
He is not seeking revaluation.
No, my lords, what I'm trying to say is, under this 3-tier system, the student is also given the benefit of revaluation. Supposing he is aggrieved by the marks after he obtains the photocopies, then also he can apply for evaluation, and revaluation. In the revaluation process, what I'm trying to bring to your lordship is, in the revaluation process, the subject expert, a teacher, experienced teacher or a principal of a school, is made to sit to verify that answer sheet under this 3-tier system, 3rd process. And thereafter, whatever changes are made, either increase or decrease, that is final and that is to be accepted as per the Annexure 3, that particular notification that my learned friend is banking on. And under that process, this student had applied for the first verification. Everything was, the totaling was to be correct and no change was communicated to him. Thereafter, he had
totaling was found to be correct by whom?
By the officials.
No, but it's not correct now.
No.
Current it is.
No. What I'm trying to bring to your lordship's notice is that was at that point of time it was correct. But after the obtaining of photocopies and revaluation, in the revaluation process, that particular 36.36 question number 36, the marks that he had secured was brought down, where the subject expert found it to be incorrect and has awarded 0. That is the case of the CBSE in my counter also.
Where is that?
That I have stated. Your lordship may kindly come to my counter.
No, counter all right. If it is brought down to 0, where is that material?
That material has been communicated to him.
Where is that? It should be reflected on the answer sheet, no?
Your lordship may kindly come to page 27 of the rate application.
Rate application.
My lords.
27.
Go to next.
What is this? 37/2024.
37/2024. The subject is revaluation of marks in respect of roll number such and such. This is for reference so and so. Your lordship straight comes to subject 184, English language. Old marks 95. This is 96. One of the subjects that he had applied, there's an increase in 1 mark from 95 to 96. So there is a change which has been communicated. Thereafter,
No, we are not on that now. We are asking simple question to you. Arithmetical errors.
That's it.
They don't need arguments at all.
no, at that point of time, which my learned friend points out is that they had given 3 marks and that was reduced. It was in the third leg where the subject expert found that the answer was not correct.
Where is that?
That I have stated in my counter, but
No, you may say in counter so many things. Where is the material in support of your counter? Counter is a product of your brain.
No.
We are asking the action of the concerned board.
No. The counter is based on certain documents, my lords.
Show that.
But that documents, if your lordship permits me some time, I'll produce them. Because the counter is prepared on particular document. That document is not with me.
Therefore, we can't look into the counter.
But
Counter without a document.
No.
No counter.
No. My point is, counter has been prepared on the basis of certain documents, but that particular thing is not with me. So that is what I am.
You are bringing it tomorrow.
I'll bring it
Tomorrow.
Your lordship may call it day after tomorrow.
Day after. That's the request. What is this? There is a one famous judgment.
What my brain?
There is a one judgment of very old judgment of Apex Court. Hari Vishnu Kamath versus election tribunal. H.V. Kamath, you are one of the members of the Constituent Assembly. There the Apex Court discussed what is an error apparent of the face of the record. An error which can be demonstrated without argument is an error apparent on the face of the record. My Professor Pratap Vishweshwaraya used to very often put that judgment. Any standard book on law, it's like Ansariya, Bale Ansariya, V.G. Ramachandran, they have that judgment. It is so apparent that 4 answers he has given. One is 1 and 2, and second one is split into 2. For each one of them, 1 mark is allotted. And if you do not come, and the very competitive world is this nowadays. The competition is so high.
That's
It's very, even a fraction of a mark will count.
right.
Denying meritorious candidate 2 marks is a real injustice.
Yes.
He will feel very bad.
Yes.
He will not believe the judges at all. He may show.
What your lordship says, I do bow down to that. But the question is that the particular notification
No
that
question. Answer is. You have to say answer.
My lord,
I probably
Yeah. Urgent to they are on request of counsel appearing for the university. Thank you.
Item 73, interim order to continue.
70 interim order to continue. For the last week of January. Hi.
My lord, item 62, your lordship. Is the urgent matter number? 62 next week.
With the bench. 69.
Item number 69 item. 62. 62. May minutes next week minutes needed 11. 11 minutes.
What is that matter about?
I am for the opposite party number 2.
What is that matter about?
The MSFC matter proceeding has been stalled since March. Next week, 12 minutes if possible.
Item 61, let the CW, the matter of the concerned CW of Bhadra denied the representations of his father, and for that, today the date is fixed for the response of the CWC.
We'll have it on 20th of August.
item 70. Item 70. That a Anganwadi center, construction of the Anganwadi center has been stalled. Your lordship. Yes.
Which is that? What is that matter?
Allowed to sign the account system, all the visa duty.
Since how long?
Since 1 year.
Here. We'll have it in first week of September.
69 matter. My lord was pleased to that batch of programs pension matter on September minute. Did it come on September?
Do you have any connected matter with you?
Connected.
Calling.
Matter 67 is a fully covered matter. There is the RSCP matter, Ashok Mahapatra's case, my lord. This may be my lord 74.
68 and
My lord,
68 and 75 also.
67 and 74.
we are posting them on a Thursday, na? From Saturday. Next Thursday night. Next, Thursday next.
Some 65 melody. High melody, any date?
65.
65.
What is that matter?
What is that? House rent matter melody.
Correct.
House rent.
Any urgency?
No, it's not action.
We will have it in second week of September.
First week.
First week of September.
Item 71 and 76, my lord. Item 76. So, the covered matter, my lord.
77.
My lord, I'll take it up tomorrow.
Covered matter.
My lord.
Tomorrow we have many matters, brother. We'll have it next week. We'll have that.
My lord, item 71 and 76, my lord.
I have a covered matter at item 59, next matter. 59.
Covered matter.
Yes.
Week after next we'll have.
71 and 76, my lord, covered matter. Awesome.
79. Matter relating to building plan.
Yes.
We'll have it in first week of September.
Item, my lord, 71 and 76. 71 and 76, my lord. Lordship covered by Awesome Mapatra case. RSCP.
71, 76.
Yes, madam.
Week after next.
70, sorry, true. 72 and 76.
72 and 76. Week after next.
Item 62, arbitration is halted, my lord. Next week we have currently taken, my lord.